Aldridge is in custody? Yes. Where's Miss Robinson? She's across the hall. Right in there.
Running was
We talked to Miss. I'm asking students about Aldridge. Did we talk to Miss Robinson about Aldridge? Miss Robinson was not. So I said I'm the page. She's not the prosecutor. You did not talk to Miss Robinson about Aldridge?
I talked to her, partial response was that she was still having to talk to her client this morning to find out the final decision whether I wanted to.
Also, board is present.
He is speaking with his attorney right now about a potential resolution.
On the record in the matter, the people of the state of Michigan versus James Leggions, file number 24-02146.
Yes.
Good morning, Your Honor. Natalie Maycomer on behalf of the people.
Good morning, Your Honor. Daniel certificate number 82936 on behalf of Mr. Leggions.
Okay, and today's the date that was scheduled for another probable cause conference. I found good cause to go beyond the timeline. I do have a substitution of attorney that I just signed. So you just substituted in on this matter. Did you receive discovery yet?
I have received discovery this week. I have discussed the matter with my client twice now. However, there is some outstanding discovery. That's the reason people request for adjournment. And I did discuss with my client the 21-day rule. He's willing to waive that.
I found good cause already. We've already gone beyond. It's supposed to be, his exam was supposed to be today. And I found good cause last week to adjourn because he didn't have, because of the conflict. So we don't need to do it at this time. But you have additional discovery that's pending.
Yes, sir.
Okay.
Wording some statements that my client made. I don't have that.
Is the expectation that the prosecutor's office should be able to get that to him shortly?
I believe so, Your Honor. This is actually Melanie Smith's file. I know that Ms. Smith and Mr. Sturdivant were going to do touch base today to make sure that whatever was missing, we were able to get over to his office as soon as possible. And that's something that she is currently working on.
Okay, so I'll set this for a preliminary examination. September 26th at 8:30. Is it Leggions, you said?
Leggions.
Mr. Leggions, are you, do you have any questions for the court today?
So I have my preliminary September.
It's gonna be September 26th at 8:30. Do you have any questions, sir?
Oh, that's good.
I'm sorry?
I'm good. I'm fine.
Any additional matters for the record, counsel?
Nothing from the people.
Nothing for the defense. Thank you.
P82936.
Your Honor.
Do we know if we're proceeding on Slester?
I'm not sure, Your Honor. I just had, to go and check with Adam and see if they're ready. I know Adam, Blogger, and Chapman.
Is it done with me?
Free to go, sir.
Huh?
You're free to go.
Thank you very much.
Mr. White, is your attorney, is your client present?
Sorry, I had to unmute, Your Honor. Yeah, I think I saw that Kennedy Atkinson, you can see, I see his image in here.
Okay. On the record in the matter of the people of the state of Michigan versus Kennedy Atkinson, file number 24-02062, counsel appearance.
Good morning, Your Honor. Natalie McMiller on behalf of the people.
Toby White on behalf of Mr. Atkinson. Mr. Atkinson, please unmute at this time.
Okay, today's the date that's set for a preliminary examination. If the defendant is on 24-hour house arrest. Why are we not proceeding today?
Your Honor, we're not proceeding because Mr. Kennedy was released from a mental situation and he decomposed last week. And so we were unable to prepare for the examination today. So we're asking for a waiver. He's now been to receive medical treatment, I said, outside of Stonehenge, where he was, locally, and he's stabilized now. I think he's in good shape to be able to understand this proceeding and should be able to go forward and proceed in helping me prepare for a preliminary exam in the near future.
Are you saying he was hospitalized?
He went to the emergency room twice. And they readjusted his medication, took him off some medication and put him on different medication.
Okay, and he's in the position now to understand the procedure and to waive the timeline?
He is, Your Honor.
Okay, Mr. Atkinson, you can hear me correct, sir?
Yes, Your Honor.
Okay, so you have the right to have a preliminary examination within 21 days of the date that you were arraigned, which you were arraigned back on July 23rd. So your matter was scheduled for an examination today. Due to your personal health or medical situations within the last week, you have not been able to meet and properly prepare for your exam with your attorney, that's correct?
Correct.
Okay, so you're willing to waive the timeline so that I can reset this?
Yes, Your Honor.
September 12th at what time? 8:30. September 12th at 8:30 work for you, Mr. White?
Pulling the calendar right now, Your Honor. September 12th at, 8:30?
Correct.
Yes.
Okay, we'll continue to that date and time. Any additional matters for today's record?
Nothing for defense, Your Honor.
Thank you, you're all set.
Thank you, Your Honor.
You're welcome. You're welcome. Here to go, Mr. Atkinson.
Thank you, Your Honor.
You're welcome. On the record in the matter of the people of the state of Michigan versus James Wiggins, file number 24-02143, counsel appearance.
Good morning, Your Honor. Natalie McMiller on behalf of the people.
Good morning, Your Honor. Jacob Sargent, fourth assistant public defender here. Mr. Wiggins, he's present. He's a counsel table. Please stand at the right.
Okay, today's the date set for preliminary examination with count of assault with intent to great bodily harm, less than murder, and 2 counts of domestic violence. Are we running an exam today?
Your Honor, I understand that defense is asking to run the exam. I have not been able to call the hallway yet for the subpoenaed victim and witness, and I have not seen the officer, but I have not checked the other hallway either. So I have a few moments to do that and know. See if they're. I did just go call the hallway for both Erica Bergman and Stevenson or Raquel Bergman. Neither were in the hallway. And the officer that has been subpoenaed is also not here that I can see.
That's been moved to dismiss, Your Honor. Thank you.
Motion to dismiss is granted without prejudice. The people have the right to reissue the charge against you within the statutory time frame. Do you have any questions about that? I can give you your copy of your dismissal in just a moment.
Thank you, Your Honor.
You're welcome. Is he on tether at all? Anybody else? Mr. Starks, is he on tether at all?
Sir, are you on tether? No.
Okay,
Thank you.
tell him to wait for his dismissal.
Wait for your dismissal. Okay, thank you.
Let's see. Starks, you have some people in custody. Mr. Yang, you're here on which matter?
Mr. Dante Walls, Your Honor.
And so, Mr. Starks, you want us to bring Ms. Chapman up or Edwards?
Mr. Chapman, Adam Piper's on that case. I'd like the opportunity just to talk to him before we get started, so perhaps
About Edwards?
about, well, Edwards, that's a good question, Your Honor. I'm prepared to go with Mr. Edwards, prosecute the makeover. It's ready on that one. We're scheduled for 9 o'clock now as well.
Okay, we'll bring up Edwards. Why she's not in here? They didn't bring over Wiin.
Yeah.
Why?
They said that he wasn't on the list, but he's on the jail list. That was-
He was on our jail list? Well, then they need to bring him over.
Okay.
No, it was Mr. Wiin. Yeah, if they missed it, they just have to do an extra. Okay. Jail ain't that far. I'm sorry?
I said I'm 21.
I don't know. The, like lockup has to go get him? I don't know. Isn't Marquita here? She is, or conference? They're telling that he wasn't brought over, he needs to be brought over. Exams today. And then.
Morning, Your Honor. Morning.
Good morning. Mr. Ferguson is on blocker.
Yes, as am I. Before the game blocker, we do need to speak with the court in chambers.
I didn't say you were going blocker right now.
I apologize. I'm sorry. I thought Ms. Maycomer we were.
No, I actually, this is the first time I mentioned Blocker's name today, actually. I just saw Mr. Ferguson, so I said you're on Blocker, so you're here.
For that.
I did mention another one that you're on though, Mr. Piper.
Yes.
Mr. Starks needs to speak to you about it. Chapman?
Yeah, I'm going to talk to Mr. Chapman once we sort out what's going to happen with Mr. Edwards, Your Honor, please. Thank you.
Okay. But you need to speak to Piper already, you said?
No, we've
Oh,
already
okay.
talked
We
this
talked.
morning.
Got
My
it.
apologies, Your Honor.
No
I
problem.
just need to talk to him.
So Piper's on Blocker and on Chapman, and is that it or another one?
Nope, that's all I got. I have another one with Ward, but that's all I have here this morning.
Are we gonna be starting? Block channel.
Are we gonna be doing what? I didn't hear.
Starting on blocker shortly or the time to talk to.
I've been here on the bench and nobody's ready to go. I don't know if anybody's ready to go
I'm ready.
because the case was for 9 o'clock.
Yeah.
And we got a lot of cases that have to go today.
Yes, I'm on board with it.
And we have a courtroom full of people.
I'm ready.
So
to
the
go.
court's ready.
I'm ready.
You have to speak with them, you said?
No, I wanted to talk to another client for.
I didn't hear you.
Another client for as well.
Oh,
We should be
okay.
ready on blocker.
We're ready on Blocker. If that's the only one ready to go, Blocker can come up.
While they're bringing him up, if we could speak with the court in chambers about
Yeah.
what we should still be doing.
We can grab Blocker. On the record of the matter of the people of the state of Michigan versus Malik Leon Blocker, file number 24-01407. And I have 24-00655. Council appearances, please.
Yes, good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Malik Blocker, who's standing to my right today.
Okay, how are you, Mr. Blocker? Okay, today's the date that's set for preliminary examination. I have 2 files and then at the bond violation. And we are prepared to proceed today, correct?
Yes, Your Honor. People are ready.
Defense is ready as well, Your Honor.
Okay.
The only thing I would ask, if there's more than one witness, I would ask for a
Sequestration will be ordered.
Absolutely.
Okay, and then preliminary matters.
Yes, Your Honor. The victim expressed to me that while this case has been going on and waiting for this examination, she's been harassed by numerous members of the defendant's family, and we'd ask that those members be removed from the courtroom during these hearings. I have a list of specific names who would like me to read them all.
Okay, just so I can. Clear. There's been some ongoing allegations of witness intimidation and harassment.
Yes, Your Honor.
Okay, and so the concern is that those individuals are here today.
Yes, Your Honor.
Let's hear from Mr. Blocker. Please stand if you're here for Mr. Blocker. If you're here in support of Mr. Blocker. What's your name, sir?
I'm Smith.
You said Smith?
Yes.
Your name, ma'am? What's your relation to him?
Grandparents.
Grandparents, okay, your name, ma'am? Your name is Malika Blocker?
Yeah.
Okay, his mother, and your name, sir? I can't hear you. What's his name?
Martez McKenna, he's his brother.
Martez McKenna, and your name, ma'am? Relative? And your name, sir?
Hello, Western.
Okay. Anyone else here for Mr. Blocker? There's people in the hallway?
Yeah.
Okay. Okay, what are the names?
The names, Your Honor, are Malika Blocker, Marquise Blocker, Martez Blocker, Marquand, Ayana, Myra, and Nora. Those are the names she was able to be able to spoke to her this morning.
Those individuals can be removed from the court. You can watch it via Zoom, though. We are live on YouTube. Just the individuals he named need to be removed. Anybody else can stay inside the court. Any additional preliminary matters before we proceed?
No, Your Honor, people are ready.
Ready as well.
You can call your witness.
Thank you. People will call Kira Rich.
You raise your right hand first, ma'am. And you stand, face me, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury? Okay, you can have a seat. Okay, there's a microphone that is in front of you. The lady behind you is my court reporter. She has to take down everything being stated in the courtroom today. So I need your voice to be loud and clear. It sounds a little low, okay? Okay, we also may have fans going and because of the amount of people in the courtroom, I may need to turn an additional fan on. So we need to, even if you feel like you're yelling, that's okay. We need to be able to hear everything and it needs to get beyond this plexiglass that's surrounding you as well. Now, if there's an objection from either attorney, you will stop speaking immediately. I have to make a ruling on that objection and then I can advise you then whether or not you can give us that answer or not, okay?
Okay.
State your first and your last name, spell both.
Deyra, last name Rich.
Okay, counsel, you can proceed.
Thank you. Good morning, Deon. Deon, I'm gonna read off the list of names to you that was read into the record before we came to this courtroom. I'd just like you, after I've read them off, to tell me if you see anyone matching those names in the courtroom, okay? Those names are Malika Blocker, Marquise Blocker, Martez, Marquand, Ayana, Myra, and Nora.
No.
No. Okay. Now, I know those are the names you gave me. Is there anyone else still in the courtroom apart from the defendant who has been engaged in harassment or less? Kara, do you know Malik Blocker?
Yes.
How do you know him?
I can't hear.
It is very much against the instincts to shout in a closed room, but please do your best to speak up. If you're getting too soft, we're all gonna remind you, okay? So how do you know him? And were you two in a dating relationship? How long were you guys together for?
About 5 to 6 years.
Now, do you see him in the courtroom today?
Yes.
Could you please point out where he is located?
On the left side.
Left side, is he sitting at the table?
Yes.
And is he all the way on the left side of the table?
Yes.
You have the record reflect that she has identified the defendant in this matter.
In the objection.
No, Your Honor.
Identification noted.
Now, here I'm going to ask you about two different incidents, but the one I want to focus on first is a more recent one. Now, was there an incident with Mr. Blocker on May 9th of this year, 2024?
Yes, I did.
And you end up having to speak to police about that?
Yes, I did.
What are you able to tell us about that incident?
Ford, behind my car with his brother. His brother's girlfriend's car. He had came over to my car door. And he had pulled out a gun on me.
Now, were you still in a relationship at this point?
No, I was not.
And do you remember what kind of gun? Was it a handgun, a shotgun, a rifle?
A handgun.
And did he point it at you? Where were you at that point?
I was in my car.
She was doing what?
You said you were kind of in your car?
Yes.
Now, what do you mean by kind of? Were you sitting in it? Was the door open?
The door was open, but I was already on my way to closing it.
Okay, when he came up with the gun?
Yes.
How did that make you feel?
I was scared.
What are you able to tell us about what happened next?
Yeah, told me to roll down the window or he was going to shoot me. I seen one of my neighbors walking the dog out of just the shadow of this. I tried to crack the window and try to make him out that he had a gun in his hand. And
what happened next?
My neighbor kind of like ignored the situation. So I was kind of running out of time. And I got scared, so I unlocked the door and inside the car.
Now, you said you were running out of time. What do you mean by that?
It's kind of hard to explain when he's mad.
Were you worried that it
Short
was,
term.
were you worried it was going to, he was going to shoot you?
Oh, yeah.
So he got inside your car. What can you tell us happened once he's inside your car?
He pointed the gun at me and told me to drive. I tried to ask him to put the gun down, and he refused. He had me drive all the way to Richwood. First had a relationship.
Now, where were you at when he initially pulled the gun?
I was outside my apartment complex,
And where is your apartment?
asking Hollows.
Is that in Lansing?
Yes,
So that's in Ingham County.
yes.
Now, when he had the gun on you, do you feel like you were able to leave that situation?
No,
So he had you drive to your relationship again. What can you tell us happened once you got there?
On the way over there, he just kept yelling, and he said if I was to get the car pulled over, that he was going to shoot me. I tried to get him to stop yelling, and to put the gun down, and he still refused. He then rolled down the window and stuck his body halfway out. And he still proceeded to point the gun at me, like if he was going to shoot me again. So I had to just try to just drive straight. I was having an anxiety attack. And that's who made it over there to Richwood and crime complexes. We had parked, and he was just screaming at me. And he had the gun pointed to me. I tried to gently push the gun down out of my face, and he got louder and got madder and was yelling in my face even more.
How did that make you feel?
I was scared.
What can you tell us happened at this point? You're at this complex. He's got the gun in your face. He's not removing it. What can you tell us happened next?
I tried to ask him why was he doing this, and he simply said that it's because he had got locked up in the past, and he wasn't on his son because
He blamed you for that?
yes.
She said he got locked up in the past, and what happened?
He wasn't allowed to see his son because of her. Oh. Why did he blame you for that? So whose apartment was this?
The one in Georgetown or Richmond.
So you guys went to the one in Richwood, right?
Yeah.
Whose apartment was that?
That was ours.
It used to be yours?
Yeah. And then past like years ago.
Now, at some point, they ended up going to the Georgetown one?
Yeah, after I had gotten him to calm down, because I figured me crying and stuff wasn't help the situation and calm him down.
And so whose idea was it to go to the Georgetown apartment?
Me, I tried to get him to calm down, and I just apologized for everything to him. And I said that I was gonna do better and I was sorry.
Now, why did you say that?
So he could calm down.
Just for your sake.
Yeah.
Now, the Georgetown apartment, that's yours, right?
Yeah.
You're trying to get home?
Yeah, I was coming back from,
I can't hear anything she's saying.
I was coming back from my kid's visit.
Tell you what, I'm gonna stand back here. Let me try and speak up like you're talking to me all the way back here, or even with your support people who are in the back of the course, okay?
Okay.
I know it's very hard to speak up during these types of things, just do your best. So, after he had the gun in your face, you convinced him to have you go back to your apartment, right?
Yes.
Now, what happened once you got there to the Georgetown apartment?
He was still a little bit angry, but he was calmed down more than what he was already.
Now, you ended up going into the apartment?
Yes, we did. We were that there.
Did you want him to go with you into the apartment?
No, I didn't, but
He had a gun on you?
yeah, and I had no other way. It's nighttime.
So he followed you in.
Yes, after we got off the car.
Do you remember if he still had the gun pointed at you during that?
No, I was speaking forward, so I don't remember.
Now, do you remember speaking with an Officer Dean that day
Yes.
about this incident? You remember telling Officer Dean that
Objection, Your Honor. This is hearsay.
it's literally impeachment?
Objection, are you withdrawing your objection? Okay, thank you.
Thank you. Do you remember telling Officer Dean that Malik made you walk through the back entrance of the apartment building with the pressure of the gun still on your back?
Yes, I was, this incident that I just told you about was,
I couldn't hear you repeat it.
this incident that I just told you about was May 8th.
So he
That
did this,
incident was May 9th.
so he pulled a gun on you on May 8th, and then he also pulled a gun on you on May 9th.
Yes.
So the May 8th one, he pulls up on you, gets in your car, points the gun at you, makes you go back to the other apartments where you guys had started. And then you commit to go back to Georgetown. Okay, I am so sorry. I thought we were talking about May 9th, but you clearly remember these two different incidents. So let's focus on May 8th right now. So for May 8th, he walks in with you into the apartment, right?
Yes.
And you didn't want him to. Did you feel?
Sir? Is there a reason why you're speaking so that I can't hear? Okay, you can continue.
Okay. Now, on May 8th, did you invite him into your apartment?
No.
Did you feel like you were able to tell him no when he was coming in?
No.
Why?
Yeah.
Now, at this point, had he just threatened with the gun, or he actually made physical contact with you? How- What can you tell us about that physical contact on May 8th?
From the gun at me. One time while driving.
Ma'am, can you turn in my direction, please, so you can see me? If you were in a fire and you needed to call for help, would you use that voice?
Yeah.
And you think someone can hear you saying help? You have children?
Yeah.
Do you have to get their attention sometimes
Yeah.
and use that same voice, that low?
Sometimes, yes.
Okay, well, I need you to use the voice that you would use if you were yelling for this guy back here in the corner to tell him that there's a fire in here. I need you to use that voice because I am struggling to hear what you're saying. And if I can't hear, I can't make a ruling, okay? And it's okay for you to listen to his question, but look at me when you're answering because you're actually answering for my benefit, okay?
Okay.
So, Jerry, you didn't feel like, actually, oh, there's a few questions ago. I know he was pointing the gun at you, but did he ever actually on May 8th strike you?
With the handgun,
Yes.
in my eye.
He hit you in your eye on May 8th. Now, did things calm down once you were inside of your apartment on May 8th?
Already,
What happened once you were inside of the place?
he was pacing back and forth, looking out the bedroom window, my kid's window, the other living room window.
Okay. And did things get violent again inside of that apartment on May 8th?
No, I just went in my kid's room and cried myself to sleep.
And then at some point, did he leave your apartment?
No,
So when you woke up on May 9th, was he still inside of your apartment?
yes,
At some point, May 9th, did he leave?
yes,
At some point, May 9th, did you leave?
yes. I had to lie to him and tell him I had an interview at 11.
In order to be able to leave?
Yes.
Now I want to take us to what you talked about with Officer Dean on May 9th. So on May 9th, did you? Right, right, phrase this. On May 9th, was there another incident with Mr. Blocker?
Yes.
What can you tell us about that incident?
He put up a gun to my back and forced me inside after I came back home.
Okay, so that's the one where he physically forced you back into your home.
Yes.
So is that when you felt the pressure of the gun in your back?
Yes.
Were you worried at that point that he was going to shoot you?
Yes.
And that day, did you want him in your home?
No.
He forced you inside your home.
Yes.
What can you tell us happened once you were inside your home on May 9th?
He was so upset. And he was asking me why I was gone for so long. And I lied to him and told him I was running errands and trying to get space to calm down.
Did it work?
Just a little bit. He was still pacing back and forth, and I got him to calm down by just not paying him any mind and just doing stuff around the house.
At some point, did he threaten to kill you?
Yes.
What did he say?
He was gonna kill me on my sister's death day.
On your sister's death day?
Yes, that was May 8th, 1975.
At some point on the 9th, did he actually punch you?
No.
On the 8th?
Yes.
Now, when you were speaking with Officer Dean, were you telling him about parts of each of these incidents?
Yes, it was 3 officers talking to me at once.
At some point, did he try and stop you from calling police?
He didn't know I called the police. When I had left, and I told him I had an interview at 11, I went to Downey Duncan Speedway and I had called the harassment line. I reported that incident that happened on the 8th, and I asked him not to air it because he listened to police screams.
Now, do you remember telling Officer Dean that while Mr. Blocker was attacking you, he said if you were to scream before the police got there, he was going to kill you?
Yes.
And did he say that?
Yes.
Sir, if you can't be quiet, we can continue without you.
If it happens again, Your Honor, people are going to be requesting that.
You can continue.
Thank you. Now, Your Honor, just as a housekeeping matter, we also have a key reset for today. Would you like me to take that testimony now?
However you feel is appropriate to lay it out.
Thank you.
I'm following.
Now, Kira, at some point you're aware that Mr. Blocker was arrested, right?
Yes.
And that there was no contact order put in place?
Yes.
Did he try and contact you while that no contact order was in place?
Numerous times, even after he got locked up, the same day and after that.
He was calling you from the jail?
Yes.
And did you pick up the phone?
No.
But were there voicemails left?
Yes.
In those, does he talk about court?
Yes.
Was he trying to convince you to help him out with court?
Objection leading, I think she's leading the witness. Your Honor.
How did you want to respond to the objection?
I will rephrase. What was he saying in regards to court?
So don't do me like that. And don't leave from hanging.
And What message did you receive from that? What was your takeaway?
Not the charges.
Now, I want to take you back to an incident last winter. Good. Also speak with police about an incident with Mr. Blocker on December 5th, 2023.
Yes.
Now, at that time, were you two still in a relationship together? Not after that incident,
Yes.
but at the time of that incident, you guys were still together.
Yes.
And were you two still living together at that point?
Yes.
Now, where did you make contact with police that day?
Hospital.
Hospital. Were you able to tell us about the incident that made you go to the hospital?
Yes. It was December 5th, and I had woke up. We had just had a little argument the night before after I got out of work.
By we, do you mean you and Mr. Blocker?
Yes.
Please tell us, what are you able to remember happened as the argument started?
He didn't really want to talk about it. So he kind of ignored me. I asked him, was he okay? What's wrong with him? And I felt like I was trying to ignore his opinion on things or how the argument was and how he felt. And he slammed like a couple of cabinets, and then I went in the bedroom. And I went in the bedroom, he came in there and he got in my face.
What happened once he got in your face?
I told him to get out of my face, and I didn't like shove him, but I just pushed him a little bit out of my face. His nose,
So he was that close.
yes.
And what was going through your mind as he got that close to you?
I wasn't too sure on what was going to happen next after that.
What can you tell us happened after that?
He swung on him.
What do you mean by swung on?
He punched him.
Where did he punch you?
He punched me everywhere, and he could punch me.
And it proceeded to more than just punching?
Yes.
What can you tell us about that?
He hit me with a curtain rod. He hit me with a aggressive will. He kicked me, he pushed me back down. I told him that I couldn't breathe, and he told me to shut up, and then he didn't care. He kept punching me.
Now, what do you mean by you couldn't breathe? What was making it difficult to breathe?
It was early in the morning. I didn't drink or eat anything that day. And I was about 18 weeks pregnant with my daughter.
Now, at some point, do you remember telling Officer Hare that day that he had you on a headlock on the ground with his legs?
Yeah, when I was on the floor.
Did he actually have you in a headlock that day?
Yes.
And was he applying pressure around your neck with his legs?
Yes.
And was that contributing it to making it difficult for you to breathe?
That's a yes.
Did you try and get away from him while this assault was happening?
Yes, but it wasn't working. He followed me everywhere.
So he wasn't letting you get away?
No.
Did he try and stop you from just getting up off the ground?
Yes.
And was he successful in stopping you from getting up off the ground?
Yes.
How would he try and stop you?
He would kick me back down. He punched me back down.
At some point you were eventually able to get back up?
Yes.
How? And your kids crying helped be a distraction.
He went to look in the room.
So when he was looking at your kids, that's what they were actually kept.
Yes.
Did the assault continue that morning?
It calmed down after a little bit. I called my kids, their grandparents, trying to call everybody else. So that way they can come get my kids and then I can leave. Even in the middle of that, we just kept pacing back and forth and he would throw something at me and he would hit me again.
Did he eventually like it this way? When he threw stuff at you, did some of it actually hit you? And what type of things was he throwing?
He threw flower base at me in my head.
I'm sorry, if you speak up a little bit.
He threw a flower base at me in my head. A backpack full of his paperwork from jail.
At some point during this assault, did he threaten to kill you?
I can't remember too sure. There was a lot that day.
At some point, did he think you called 911?
Yes.
And what was his response to that?
I can't remember that far back.
Do you remember if he was pleased with that thought?
I know that he wasn't. I had to convince him that I didn't.
Suffer any injuries from that incident?
Yes, I did.
What injuries are you able to remember from that?
After I had got my kids out of my home and I had went to my auntie Timothy's house, I again there passed out and I was driven to the hospital. My wrist was fractured. I had very bad bruises on my back. I had a black eye, I had a busted nose, a busted lip. I had bruises on my fingers and on my legs.
What was fractured?
My wrist.
Wrist.
Now that occurred, was that at the Georgetown address?
Yes.
So that was in Lansing.
Yes.
Um,
Yes.
What's the address again?
That was 1400 Georgetown. Now, I promise I'm almost done with my questions. I asked you about calls he made to you from jail, and you said it was around the time he was arrested in May.
Yes.
Now, we were here for this hearing before, and it didn't end up going that day, right?
Right.
Between then and now, did he try and contact you again from jail?
Yes.
And how do you know that?
I got my number blocked from the jail calls and so then tried using my email.
So he tried to request a connection to you over email?
It's like a smart jail link, something that looks like jail pay.
Do you know anybody else at the jail?
No,
Anybody else at the jail have any reason to try and connect with you?
no,
Was that sometime around mid-July?
July 17th.
July 17th. Thank you. Connor, I have no further questions at this time.
Cross-examination.
Thank you. Good morning, Mr. I want to turn your attention back to December 5th of last year. So you were at home on Georgetown Boulevard, is that correct?
Yes,
Can you speak up just a little bit, please?
yes.
And who was present at your home that day?
Malik and a bunch of my kids.
Okay. Was Malik living there at the time?
Yes,
And were you watching a movie that day?
December 5th?
Yes, ma'am.
No, we were just waking up, it was like around 9 to 10 o'clock in the morning.
And you said there was some kind of argument, is that correct?
Yes,
Do you know what the argument was about?
he was upset about how I was reacting to the situation after I got off the work with him picking me up.
And were you goading him or egging him on in this argument?
No, I was not.
Okay.
I was giving him the silent treatment.
Why did you give him the silent treatment?
There was no point in arguing with him and me knowing how his anger is.
Could you have asked him to leave or anything like that?
No,
Did you ask him to leave?
no, I did not.
No one else was present but you and Mr. Blocker and your children, is that correct?
Yes,
And see, the law enforcement was called that night, is that correct?
it was called 3 times. They responded to a late call at nighttime.
Okay. And then you said there was an incident that occurred in May, is that correct?
Yes,
And you said there was an incident on May 8th, is that correct? What time of day was that on May 8th?
yeah, May 8th and May 9th.
Let's talk about the one in May first. What time of day did that occur?
Roughly around nighttime. I'm not too sure at the time.
So it was almost into May 9th, is that correct?
No, the end of May 8th.
But like in the evening?
No, it was
Evening,
nighttime,
like 8, 9, 10 o'clock?
around that time.
Okay. And you call cops, law enforcement on May 8th?
No, I did not.
And you said that that incident continued into the night, is that correct?
Yes,
You said you called law enforcement on the 9th, is that correct?
yes,
When you gave a statement to Officer Dean, did you mention anything about Officer Dean, what occurred on May 8th?
yes, I did. It was 3 officers talking to me at the same time also.
And on May 8th, was he living in the home?
No,
And did you ask him to leave on May 8th?
I couldn't.
Were you watching a movie on May 8th?
No,
Any TV or anything?
no.
How often did he come over in May before the 90 alleged incident?
He didn't come over at all.
Okay.
He popped up on me randomly and then tried to scare me into missing, not to proceed with the court hearings.
I'm talking before May, how often would he come over to the house?
Yes, and that's what I'm talking about.
He wasn't living with you when you guys were broken up at that point, is that correct?
No, after December 5th, he went back over to his sisters.
Okay. You said you have 2 minor children with Mr. Blocker, is that correct?
Yes,
And a 3 or 2?
Two.
The newborn and the other child, is that correct?
yes.
Do you know if there's a custody order in play?
For what?
Family court about custody of the children?
Yes, we're going through child and families right now for the incident in December.
Okay. Was that the first time you were in front of the court, or was there other orders prior to December 5th of this year?
Yeah, that's the first one for child and families.
Is it a child protective service case or a friend of the court matter?
CPS cases.
No, CPS, is CPS still involved in your family?
Yes,
And I want to turn your attention back to the night of May 8th and May 19th. What was the first thing you said to Malik?
and it's been,
May 8th,
you have to run up to the window,
correct.
ask him to stop.
You were on the phone with anybody else that day?
No,
You know if any of the neighbors came out and witnessed anything?
it was one of my neighbors who was walking his dog, and that's why I cracked the window.
Do you know if they called the police or intervened?
No, I don't know.
What about in December, were there any other neighbors present?
Not that I'm aware of.
I have no further questions.
I have a quick question. At the May 8th incident where you indicated that you were I guess, getting into the car when he initially engaged you and pointed a firearm at you. Where was that located?
1400 Georgetown Boulevard.
Okay, so that was outside of that address, okay. Any redirect?
No, Your Honor.
Okay, so I'm going to advise you, Ms. Rich, that there is a sequestration order, so that means that you're not allowed to discuss any portions of your testimony with any other witness, okay? I'm going to have you excused, and you're gonna be escorted by the court officer, okay? You call your next witness.
Your Honor, people have no other witnesses. And if I'm honest, I'm going to need 5 minutes to determine the vast number of added charges.
No problem.
That's the defense has no witness.
Thank you.
I'll let Officer Dean know it's good to go.
Thank you. And then the date of offense for the vicinity is on the property. People are ready, Your Honor. Absolutely. Thank you. Now I'm going to try and handle this from the cleanest one to the messiest one. So first, I'd like to start with bind over for 24655 FY, the incident from December 2023. There was clear testimony as to unlawful imprisonment, as he was holding her against her will in order to continue this assault against her, which involved strangulation and felonious assault. He said that she tried to leave, she was not allowed to leave. He was physically kick her back down to stop her from getting up and chase after her. Second, assault by strangulation. She said that he had her in a chokehold while she was on the ground with his legs around her neck, was applying pressure, was making it difficult for her to breathe. So I believe there's sufficient factual basis for that. Next, aggravated domestic violence. Second is yes, that's the felony. She talked about the fact they were in a domestic relationship, that he attacked her, and that he caused serious injury. Her wrist was fractured, her nose was busted, her lip was busted, and she had massive bruising, to the point where she had to go to the hospital. She actually passed out when she got to a place of safety. So I believe there's sufficient factual basis for the aggravated domestic violence. The second offense notice is the enhancement that follows up, much like a DD third. And finally, in that file, the people would be requesting one added count, that being witness interference / intimidation in a criminal case punishable by 10 years or more. The PAC code for that is 750.1227B as in boy.
This is a request to add this to the file 24-00655.
Yes, Your Honor. I'll be asking that be added in both files as both were active. The victim testified there was no contact order in place. He was calling her those days in May. So after being arrested, he was telling her, "Don't come to court. You don't want to do me like this. Help me out." He was trying to get it to where he could escape responsibility and try and make sure his witness didn't show up. So I asked that that be added to the date range of on or about May 2024 as an added count 5 in file 24-655 FY. I hope like I'd have to move into the next file where there will be a requested 8 added counts. But if the court would like to handle this one
I'm
first,
trying to follow the witness intimidation for the December 5th because my notes indicated the calls that she said she had the voicemails about don't leave him hanging. That was after the May case.
yes, but both cases he was facing with her as a witness.
Okay.
He was calling on both. I think we had a similar incident with Nathan Joyner with 3 cases.
Sounds good. Okay.
So if the court would like to handle that one first before the other, otherwise I'm happy to go into the next one.
You can do all of your argument.
Absolutely. For file 24-1407 FY, I'm going to focus first on the charged counts with the date range of May 9th, and then we'll move into the requested added counts for May 8th. They will be shockingly similar, so that is why. He testified on May 9th, came back to the house and showed up, had the gun in her back, and forced her into her home. That is textbook definition of a home invasion in the first degree, because once he got in there, he wasn't letting him leave. Well, entering, present in, or exiting, he committed a felony. That felony being unlawful imprisonment, because she did not feel she was able to leave. No one would with a gun in their back. Then, for the unlawful imprisonment, like I said, he was restraining her with a firearm. People are going to be asking that count 3 be dismissed, that being the aggravated stalking. Given the testimony, I don't feel it is. I feel there are more appropriate charges.
Whose phone is that? Everyone's phone needs to be off, otherwise the next phone that rings, they're gonna be held in contempt. You can continue.
Oh, I apologize. I spoke too soon. Sorry, with all the accounts, I forgot the part of her testimony where she said he threatened to kill her and he'd randomly pop back up in her life when she didn't want him to. So I will be requesting that count 3 be bound over on that.
Okay.
My sincere apologies.
Okay, so you're on file number 24-01407.
Yes.
You're saying you are requesting that the.
Yes.
Okay.
All right, there was a lot in this exam and my brain got jumbled for a second there.
And your argument as to the aggravated stalking was?
She testified that he wasn't a part of her life anymore, and that he'd keep popping up and threatening to kill her multiple times. He continued to contact her in violation of a no contact order. Multiple unconsented contacts. Now, count 4, felonious assault of May 9th. He had a gun. He pointed it at her. She was afraid for her life. Felonious assault. The next 3 counts of felony firearm for home invasion first, unlawful imprisonment, felonious assault. When he committed each of these felonies, he had the handgun in his possession and was actively using it. So I believe there's sufficient factual basis for counts 5, 6, and 7. Count 8 is a misdemeanor, falls up. And now I'd like to move into the requested counts for May 8th.
Okay.
First, requested count 9 would be home invasion in the first degree. Pack code of 750.110A is an apple 2. Address being 1400 Georgetown Boulevard, Apartment 1, Lansing, Ingham County. As he,
I'm sorry. You're seeking to add a count of home invasion first degree?
yes, for May 8th.
Okay. Let's see. Okay, okay, so there would be one for May 9th and one for May 5th. Okay,
Yes.
perfect. Okay.
Frankly, that's going to be the case for all the next of these, because they were shockingly similar incidents both on May 8th and on May 9th.
Okay, you can continue.
Thank you. The next requested count 10, is unlawful imprisonment. Pat code being 750.349B as in boy. Next added count is going to be 11, felonious assault from May 8th. That pack code being 750.82. Next one, added count 12 on May 8th, is going to be domestic violence, second offense notice. The pack code being 750.813,
Number 12, said it's gonna be what?
DV second. Pack code 750.813. Then numbers 13, 14, and 15 will be felony firearms. Pack code for each of those being 750.227 B as in boy, dash A as in apple. Let me know when the court's ready for the last.
I'm ready.
The last one is going to be, as in the other file, an added count of witness interference. This should be added count 16. Witness interference in a criminal case punishable by 10 years or more. Pack code being 750.1227 B as in boy. Now, as for argument on these added counts, I thought it would be easier to get them all on paper first. He showed up, pointed a gun at her, even hit her with the gun, not for felonious assault. He wouldn't let her leave. She did not feel free to leave, and again, rightfully so, because gun and threatening to kill her, which is why we have the unlawful imprisonment. And then he committed the home invasion by entering without permission while she was present, while he had a firearm, and while entering, present in, or exiting committed felonies, that being unlawful imprisonment and felonious assault. And he committed all of these on May 8th while having a firearm in his possession and using it, which is why the felony firearms are added. One for the home invasion, that being number 13, one for the unlawful imprisonment, being number 14, and one for the felonious assault, being number 15. And all of those added counts 9 through 15 will have a date range on or about May 8th, 2024 at the same location, because it started and ended at the Georgetown address. I believe that the victim was clear about what happened on which day. Even when I wasn't, she corrected me. She was clear about what he did, when he did it, and the effect that it had on her. I'm asking that you bind over as requested in each of these files. Thank you.
Mr. Bagleson?
Thank you, Your Honor. And this is the probable cause standard. It's low, Your Honor. I just asked the court not to bind it over. Question the credibility of the witness, but leave that to the court. There is the one charge, Your Honor, I do wish to expound a little bit further, and that's on the file from the events that occurred in May. People have asked for a count 3 on a stalking aggravated, Your Honor. A couple things I want to point out. Prosecutor in this argument mentioned that he was under a court order. At the time of these incidents, there was no court order protecting Ms. Rich from Mr. Blocker. There was no PPO. There was no court order for a bond violation. So it asked that charge be not.
You say the aggravated stalking on file number 24-01407.
Correct, Your Honor.
You said there was
no court order protecting Ms. Rich from Mr. Blocker. That the case from December did not get, he didn't get arraigned or court order in place until after he alleges there was no testimony about a PPO or the court order that existed protecting Miss Rich from Mr. Blocker before May 9th of this year. And I think that is one of the elements to make it a
Correct,
felony,
both of these were arraigned on the 10th.
which is the day after the 9th, since before, not after, for each statute.
Correct.
Happy to respond.
Yes.
One, that requirement is not necessary if there are threats to kill or injure, which there were. And two, I'd ask the date be amended to May of 2024, as she talked about unwanted contacts from the defendant to her, which were in violation of no contact order. And it does not need to be that every instance was, but one of the contacts in the series of contacts be in violation. But even if that's not the case, he still threatened to kill her. And it's clear these contacts were not consented to, seeing as how he had to run up on her with a firearm and stick it in her face and stop her from leaving.
Just if I may respond on that briefly. If you look at the statute, it says that at least one of these actions is in violation of restraining order. There was no restraining order at the time of this incident.
You're referencing the aggravated stalking?
Yes, Ron, that's what I'm talking about. Question, part of the stalking, with the question is part of the aggravated stalking, right?
The aggravation requires one of three options. One, he's been convicted of this before. Two, they were credible threats to kill her or someone she knows. Or three, at least one of the actions in this series of offenses was in violation of restraining order, bond condition, and things along those lines. We meet two of these problems because several of the contacts were in violation when he was calling her from jail and he was threatening to kill her. So both two of the three possible prongs for aggravated stalking have been met by the victim's testimony.
So the stalking, however, that was originally charged with a date of having occurred on or about August 9th.
Yes,
So
people will be asking to amend that to include the entire month of May.
any additional argument?
Nothing else, Ron.
Okay, Mr. Blocker, today was the date set for preliminary examination. The burden is on the prosecution. They need to establish sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. This is not a trial. They don't have to prove each element beyond a reasonable doubt. So as your attorney argued in his opposition to bind over, this is a relatively low standard. It's just more than mere suspicion that the crimes alleged occurred. And so that information can be based on information provided by way of testimony evidence. And so we have the testimony of one witness today, and the court will be the one to determine the credibility of the witness. We had again testimony from a witness, a Kiara Rich. She testified initially, and I'm going to take it in the order in which she testified because there must have been a reason why she testified that way. On or about May 8th of 2024, that she was in the area at or near 1400 Georgetown, which is in the city of Lansing, Ingham County, state of Michigan, and that makes venue in this court appropriate. She described having had a relationship, a dating relationship for about 5 to 6 years with the person she identified in the court as Malik Blocker. She indicated that he is also the father of her 2 children. She stated that on that date in question that she was, that the defendant pulled up near her car, pulled a gun out on her car door being open. She was in the process, I believe, of trying to close the door, that he told her to roll the window down, that she would be shot. She's indicated trying to engage in activity that would try to calm him down, but felt that she was running out of time, and described it being difficult to explain when he being Mr. Blocker gets upset. The defendant got inside the car that he was screaming at her with the gun pointed at her. She tried to gently push the gun down out of her face. She asked him why he was doing this, and he responded that it was because he had been to jail before and was unable to see his son. She thought that she would be able to get the defendant to calm down. They entered into the address of 1400 Georgetown, which was an address that at some point during the relationship they shared together. She indicated that she was able to get the defendant to calm down by apologizing to him, telling him that she would be better, and that while inside, well, entered the apartment, that she did not feel that she was in a position to uninvite him into the apartment because he had a firearm, that he hit her in the eye on May 8th with the gun. The defendant was pacing back and forth once inside the apartment, and that he didn't leave the apartment on May 8th. She also testified to being punched during that time frame. She testified then on May 9th that the defendant was still at the address 1400 Georgetown when she woke up, that the defendant refused to leave, that she had to lie to the defendant that she had an interview at 11 so that she could leave the apartment. That when she later returned, the defendant put a gun to her back and forced her back inside of the home, and that she was worried that he would shoot her. The defendant was very upset. She said, still asking her why she was gone for so long. And she stated that she lied and said that she was running errands, and that the defendant threatened to kill her on her sister's death day. She said that the defendant was not aware that she had made a call to the police while she was out during that time frame, and that she had asked the police law enforcement not to air the dispatch because the defendant supposedly listens to the police scanners. That the defendant told the victim that if she screamed before the police got there, that he would shoot her. She testified in relative to a bond violation that the defendant attempted to contact her multiple times after his date of arraignment, and that he attempted to contact her from lockup, and that she had voicemails that she received from the defendant referencing the court case for not leaving him like that or not leaving him hanging. She further gave testimony about an incident occurring back on December 2023, same venue, 1400 Georgetown, where the parties had been in or engaged in a fight previously, and that she had been ignoring him or giving him the silent treatment, that the defendant was upset. He was slamming cabinets, so he got in her face. She described him being nose to her, that she attempted to push him out of her face, that the defendant swung on her, punching her everywhere, hitting her with a curtain rod and a dresser drawer. She described herself being 18 weeks pregnant with their child, and that the defendant ended up putting her in a headlock and a chokehold, applying pressure, making it difficult for her to breathe. That after the assault, that she was not able to leave or retreat because he followed her everywhere. She was prevented from getting up off the ground by the defendants kicking and punching, and that it wasn't until their children started to cry that she was able to get up. She made some phone calls. Off the record. Screen has a blue screen on it. Mr. Freeman, you're here on Deaton. You're here on Deaton. Mr. Freeman? You're here on Joshua Deaton?
Yes, Judge.
Okay, is he present?
That would be Ms. McCombs. And I don't believe her witnesses are here.
Is your client here?
Yes,
Okay, is Ms. Maycomber, it's Ms. Maycomber's matter? Is
it's
that-
in the hall, but he's here.
Can you go get the prosecutor for me while she's busy?
Gotcha.
The other prosecutor.
What's the case name?
This is Joshua Deaton.
Deaton, got it.
Excuse me?
We have a plea and a dismissal on two different cases that we can do.
We can't because there's no computer.
Right, fair enough.
Turn, computer went down, yeah.
That's what I
So
thought.
I'm trying to do something that's off the record.
Yeah. I thought you said it's been here as well, but that's what you said.
Yeah,
Sorry for not saying.
no worries. There, yeah, it just randomly shut down. No, you're not so lucky. You're not going home. Let's see. So I just, if they're not ready, if they're not proceeding on Deaton, I can take care of that. Ms. Donnelly, your client's in custody?
We have Mr. Knott is in custody. Mr. Newton is not. He is here and present.
And we're running Newton?
No, we're waiving Newton. On Knott, though, I didn't know if he where he is or the AG.
The AG's on Zoom.
Oh, great. Okay, good.
Did you need to speak to the AG?
No,
Oh,
I
okay.
need Mr. Knott. I don't think he was brought over or put on the polycom. So
Sounds good. And you said Newton is a waiver?
yes.
I'll give you the file so you all can complete that paperwork right now. I just want to know, do we have witnesses on Deaton?
I'm sorry, right now, double check, but I don't, nobody has checked in and we're gonna see in the hallway so far, you know, who they are, but I can go double check on that time.
Okay, that's- Well said. Okay, yep, if you could do that, and then I can get Mr. Freeman on his way. Okay, back on the record. Okay, let's see. Okay, I think I left off where the children were crying and the victim testified that she was then able to get up. She made some phone calls. She testified that during this time, the defendant would continue to pace throughout the apartment and throwing things at her, including a flower vase at her head and a backpack with some of his jail items. And she doesn't exactly recall if he threatened to kill her on that day because she testified that there was so much going on. And that the defendant thought that she at some point called the police and he became upset. She indicated that as a result of that incident, she suffered a fractured wrist, black eye, bruises to her nose, lip, back, fingers, and legs. She gave testimony regarding bond violations. The defendant made a request to make contact with her via a smart link jail for emails. Let's see. Organize these files here. File number 24-01407. Charges Mr. Blocker in count 1 with home invasion in the 1st degree. People are adding or requesting to add, that is, a additional count for May 8th. Oh, okay, so the complaint as drafted charges in count 1, home invasion for May 9th. If the matter were to make it to trial, the people would need to then prove beyond a reasonable doubt first, that the defendant broke into a dwelling. It does not matter whether anything was actually broken. However, some force must have been used, opening a door, raising a window, or taking off a screen are all examples of enough force to count as a breaking. Entering a dwelling through an already open door or window without using any force does not count as a break-in. Second, that the defendant entered a dwelling, it does not matter whether the defendant got his entire body inside. If the defendant put any part of his body into the dwelling after the breaking, that is enough to count as an entry. And then third, that when the defendant broke and entered the dwelling, he intended to commit, in this particular case, it could be an unlawful imprisonment or a felonious assault. Fourth, that the defendant entered, was present in, or leaving the dwelling, either of the following circumstances existed: A, he was armed with a dangerous weapon, or B, another person was lawfully present in that dwelling. And the court heard testimony. I think the area that should be fleshed out on the record to explain why I am going to bind over on count 1 is that although there was not testimony that he specifically used his hand to open the door, raise a window, or take off the screen, but that he followed or essentially forced the defendant in, the victim in, that is, because he had a firearm and she did not feel that she was in a position due to her safety to not invite him into the home. So based on the testimony of the witness, count 1 will be bound over as charged as to May 9th. Count 2 of unlawful imprisonment. In order for the prosecution to prove that at trial, they would need to prove first that the defendant knowingly restrained another person. Restrained means to forcibly restrict a person's movement or to forcibly confine the person so as to interfere with that person's liberty without that person's consent or without lawful authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. Second, the defendant did so under one or more of the following circumstances. A, the person is restrained by means of a weapon or dangerous instrument. B, the restrained person was secretly confined, which means to keep the confinement or location of the restrained person secret. Or C, the person was restrained to facilitate the commission of another felony or to facilitate flight after commission of the felony. I think based on the testimony of the victim today, it could proceed under A or C, person restrained by means of a weapon or a dangerous instrument, or the person was restrained to facilitate the commission of another felony or to facilitate flight after the commission of another felony. Count 2 will be bound over as charged. Count 3 is a stalking aggravated. The people at trial would need to prove that the defendant committed 2 or more willful, separate, and uncontinuous acts of unconsented contact with Ms. Rich in this matter. Unconsented contact means the defendant initiated or continued contact with Ms. Rich without her consent and includes the following: or appearing within the sight of Ms. Rich. Either an approach to Ms. Rich in public or on private property, appearing at the Ms. Rich's workplace or home, entering or remaining on property owned, leased, or occupied by Ms. Rich, contacting Ms. Rich by telephone, or sending an electronic communication or mail to Ms. Rich, or placing an object on or delivering an object to property owned, leased, or occupied by Ms. Rich. Second, that the contact would cause a reasonable individual to suffer emotional distress. Third, that the contact caused Ms. Rich to suffer emotional distress. Fourth, that the contact would cause a reasonable individual to feel threatened terrorized, frightened, intimidated, threatened, harassed, or molested. Fifth, that the contact did cause Ms. Rich to feel terrorized, frightened, intimidated, threatened, harassed, or molested. In this case, it's being charged as aggravated, and to prove the aggravated aspect, at least one of the acts must have unconsented contact by the defendant committing in violation of a court order or a condition of parole or probation, or that the act was committed in violation of a restraining order of which the defendant had actual notice. The defense is arguing that there was no active case at the time of this alleged incident. It's unclear to the court if there was a matter previously involving these individuals, because she did give testimony regarding at least the December 5th incident, that the reason why she asked him why he was doing this to her on December 5th. And then he said it was because he had been to jail and didn't see his kids. So I don't know if there was something else going on. Nonetheless, the people have attempted to cure that argument by asking or making a motion to amend the timeline to the entire month of May. That motion will be granted, which now makes the aggravated stalking now under court order, because he was arraigned as of May 10th. And so aggravated stalking, the court is satisfied that there's sufficient probable cause that will be found over. Count 4 in this file is assault with a dangerous weapon. We heard testimony about an assault having occurred on May 9th, using a dangerous weapon being a firearm. And so the people would need to prove at trial that the defendant attempted to commit a battery on Ms. Rich, or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful or violent touching of the person or something closely connected with the person. Second, that the defendant intended either to injure Ms. Rich or to make Ms. Rich reasonably fear an immediate battery. Third, that at the time the defendant had the ability to commit a battery, appeared to have the ability or thought that he had the ability. And fourth, that the defendant committed the assault with a dangerous weapon. A dangerous weapon is any object that is used in a way that's likely to cause serious physical injury or death. Again, the testimony was that there was a use of a firearm on the date of May 9th to assault and or threaten to harm or kill Ms. Rich. The court is satisfied as to count 4 having sufficient probable cause that will be bound over. Count 5, 6, 7 are felony firearms to accompany or attach to count 1, 2, and 3. Those, I'm sorry, 1, 2, and 4. Those will be bound over to accompany those counts. There's a count 8 of domestic violence is being charged as a misdemeanor. The court does not need to address probable cause on misdemeanor. File number 24, I'm sorry, you had a request to add multiple charges on that file. There's a request from the prosecution to add a count 9 in file number 24-01407 for a home invasion first degree for the date of May 8th, and that's consistent with the testimony provided from Ms. Rich about the incident beginning on May 8th. So that she was unable to, or didn't feel that she was able to tell the defendant that he could not enter the home. The May 9th incident being that when she returned, he pulled a gun to her firearm and physically escorted her back into the home. So the request to add count 9 will be bound over for May 8th. A request to add count 10 of unlawful imprisonment for May 8th because of the testimony that the defendant prevented Ms. Rich from leaving the home. And it wasn't until May 9th that she was able to lie allegedly and say that she had a interview in order to get out of the home. So that will be added and bound over to accompany the other counts. People are asking to add a count 11 of felonious assault that assault, and it's one count of felonious assault, the court is satisfied based on the testimony that there's sufficient probable cause as to the added count 11 of felonious assault that will be found over. There is a request to add a count 12 of domestic violence. Second offense. Is that accurate?
And upon reflection, realizing that normally we don't have to get the prior conviction in, but since we're adding this one, I amend that request just be a normal DV, because to be fair, I didn't get in the date of the prior one. I can give it, but that wasn't evidence entered in.
Okay.
I think it's a little different when we're adding it, as opposed to it's already on.
There's already a normal DV on here, so I'm assuming you would want to add a normal DV for.
Yeah, it should have been charged as seconds, but that is the least of the worries at this point.
Okay.
So I'm fine with it going up as just a DV first under 750.812.
Okay, count 12 will be added as a misdemeanor. We don't need to address probable cause. Count 13, 14, 15 is a motion to add 3 counts of felony firearms to accompany the new 3 felonies, count 9, count 10, and 11, based on the testimony that those alleged actions took place by or with the use of a firearm. Those will be added and bound over. There is a request to add count 16, witness interference in a criminal case. In order to prove that at trial, the people would need to prove that the victim in this matter, Ms. Rich, was an individual who was testifying or going to testify or going to provide information at an ongoing or future official proceeding. An official proceeding is a proceeding heard by a legislative, judicial, administrative, or other governmental agency or official authorized to hear evidence under oath. Second, that the defendant impeded, interfered with, prevented, or obstructed Ms. Rich from attending, testifying, or providing information, or tried to impede, interfere with, prevent, or obstruct Ms. Rich. It does not matter whether the official proceeding took place, as long as the defendant knew or had reason to know that Ms. Rich could be a witness at that proceeding. Third, the defendant intended to impede, interfere with, prevent, or obstruct Ms. Rich from attending, testifying at, or providing information at the official proceeding. And fourth, that the official proceeding was a criminal case where, in this case, there would be a crime of a punishment more 10 years or more was charged. Based on the testimony and the circumstances, the court is satisfied that there's sufficient probable cause to add a count 16 in this file for interfering with the witness in a criminal case. As to the bond violation on this matter, the court is sustaining the bond violation based on the testimony of the repeated attempts to contact, including voicemails and jail messages after May 10th and after being told of the no contact order by this court. File number 24-00655. Incident allegedly occurring December 5th, 2023, also at the area of 1400 Georgetown, making venue in this court appropriate to her testimony of from Ms. Kiara Rich. In count 1, he's being charged with unlawful imprisonment, which we've already gone on over those elements in the other file. And the testimony was that she did not believe she was able to leave, that she was not even able to get up off the ground, and that he was successful in keeping her or preventing her at the time from getting off the ground by continuing to kick and punch her. And that he followed her around after she was able to get up and continued to pace and throw things at her and threatened to kill her and threatening to but actually, I strike that. She did not believe that he threatened to kill her at that time. She could not recall. But he thought that she was attempting to call the police, and that upset her and caused him to continue to assault or allegedly assault her, causing a fracture to her wrist, eye, nose, lip, bruises, and also bruises on her fingers and legs. So count one will be bound over to the circuit court. Count two, assault with intent to do great bodily harm, less than murder, or by strangulation. She gave testimony specifically about that December 5th assault or alleged assault happening. Assault with intent to do great bodily harm, less than murder, or by strangulation would require the people to prove first that the defendant tried to physically injure another person. Second, that at the time of the assault, the defendant had the ability to cause the injury or at least believe that he had the ability. Third, that the defendant intended to cause great bodily harm. Actual injury is not necessary. But if there is an injury, you may consider it as evidence in deciding whether the defendant intended to cause an actual injury. In this particular case, it's being charged great bodily harm, less than murder, or by strangulation. She testified that during the assault that she was placed in a headlock in a chokehold while she was on the ground. He applied pressure. She was unable to breathe. So count two will be bound over to the circuit court. Count three is charged as a aggravated domestic violence with a second offense notice, enhancing that to a felony 5 years. She testified on December 5th that they were in a dating relationship, that they also had children, at least one child in common, and she was 18 weeks pregnant with another, and that she was assaulted and that he did inflict serious injury upon her. Again, a fractured wrist, black eye, injuries or bruises to her nose, lip, back, fingers, and ears. So count three will be bound over to the circuit court. Count four, assault with a dangerous weapon, that being a felonious assault. She gave testimony that she was assaulted with, on the date of December 5th, with a curtain rod, I believe she said, as well as a vase. So court is satisfied with sufficient probable cause based on the testimony for count four. That will be bound over. And then that has an habitual offender fourth offense notice. There is a request to add a count 5. Did I get that right?
Yes.
Again, interfering with the witness, same basis as the previous interfering with witness on the other file, which is there was a court order as a bond condition not to have contact with the alleged victim, and that there was allegations of violation of that. Did I miss it? Did I miss something on that line? Okay. So both files will be bound over with additions or amendments. Today is the 8th, so your bind over date is going to be August 21st. That's not a date that you need to appear in the circuit court. That's the date the circuit court gets the file from the district court. Your next court date is going to be a pre-trial in the circuit court. Mr. Feigelson will be made aware of that next court date, okay?
We have the PA 53.
Correct. The PA 53 on this file will also be sustained based on the testimony evidence.
Technically, there were two violation reports for the one file, that being from May and then one from July. Like,
I got one from July on that one. I do see one from May and then one from July. Okay. On the 24-01407.
yes.
She gave testimony about receiving a request for a email link, I believe. And that was in reference to the July 18th violation.
She testified it was on the 7th.
Okay, the police report is for
Yep.
the 7th, the 18th, so that was on or about July 17th. The court sustained that violation. The May 23rd violation, she gave testimony, I think on cross-examined actually specifically about whether or not they were living together or what their contract was during that time frame. And she testified that he would periodically pop up randomly, actually, she said, to try to scare her into not proceeding with the case. So that would constitute violation of the no contact order. So the court is sustaining all the bond violations. This bond's already revoked. I don't even know if we need to necessarily address sentencing on the bond violations because I'm going to continue revoking his bond at this time.
Yes, sir. I think the only decision is whether to hold him in contempt of court or not.
Okay, very good. Let's see, and I've already restricted his phone privileges, email and video.
Yes.
Based on the allegations of threatening phone calls back in May.
The people would ask the bond remain revoked, the privileges remain restricted, and that the court hold them in contempt of court for the continued violations.
Mr. Ferguson, you can address the board.
Yes, Your Honor. With regard to the phone privileges, I'll leave that to the court. With regards to the no bond, Your Honor, there's been a no bond in this case has been pending since May. Of course, the case obviously was adjourned from May to now from no cause or delay or issued from on behalf of the defense. I believe it was due to court scheduling, but I believe under the court rule, after 90 days, he would be entitled to some sort of bond on this, Your Honor. So I ask that some bond be in place today. There be no bond.
If the court is inclined to grant him bond today, Your Honor, first I will note that in file 241407, he's not currently charged as an habitual. We will be charging him as an habitual fourth and amending it when it goes up the circuit, particularly as a super habitual, as he is in the other one, with the mandatory minimum of 25 years. He is now facing 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 life offenses, 6 counts of mandatory consecutive felony firearm, 1, 3 other 15-year felonies, and many of them are discretionary consecutive. He could legitimately be sentenced to 4 life sentences. So if the court's inclined to grant him a bond, I'd ask for $1 million cash. Oh, on each file.
Did you want to respond?
Judge, we would still ask that a bond be imposed. I think even if you made a bond $500,000, I don't think he'd have the resources to post. So whether it's $500,000 or $1 million, I don't know if he's going to be able to post. I'd ask for as low a bond as possible. Your Honor. I think it's still maybe it's not posting anyway, but I think $1 million would be unreasonably high. I don't think anybody can post that, Your Honor.
Thank you. The considerations that the court takes into place when setting the bond are really not whether or not the defendant can post it. That's not the concern. The concern is safety of the public, safety of the alleged victim, and risk of flight. And the court also should consider the nature of the crimes charged, the allegations. I even have to consider the fact that there's been sustained violations on recorded jail calls of the court order. I even can consider the fact that I had to instruct him multiple times today to keep his mouth closed, and he doesn't seem to be able to control himself. I think that Mr. Blocker, lastly, I also need to consider the fact that I had to remove people and prevent other people from entering a courtroom proceeding today because of allegations of witness intimidation, to where my understanding is the potential for additional or charges to be pursued against those individuals. And so there is clearly to the court a issue of the safety of the public and particularly safety of Ms. Rich, where we have two cases where he's being charged, at least in one, as an habitual offender, fifth offense. And as indicated by Mr. Piper, it's likely going to be an enhancement on the other charge. And so he's facing a considerable amount of time in this matter. The court sees where in file number 24-00655, he previously did have a bond of 75,000 cash surety. That bond had to be revoked because of the allegations that the court received on May 10th, on May 25th, some threatening phone calls and e-messages. So the court had to then revoke the bonds on those. I'll grant the request for a bond. However, it will not be a action so that I can consider his financial situation. That's not what the court is to consider. Bond in file number 24-00655 will be set in the amount of 250,000 cash surety. There's a no contact order that will continue for the protection, and GPS tether will be ordered.
I'd ask that include the exclusion zone and victim notification.
With victim notification if possible, and there will be an exclusion zone of 1,500 feet. And while in custody, his privileges to make phone calls will remain. As to file number 24-01407, a bond will be set in the amount of 250,000 cash surety. No contact order protecting Kiara Rich. You're not to be within 1,500 feet of wherever she is. There's a GPS tether requirement that will also be in place with victim notification. As to the bond violations, did you want to address the contempt on that?
One thing I'd ask judges, if there's gonna be a sense, I believe he's been in custody on this since May. So that we factor in the time that cover the maximum violation, so I'd ask that he be given some credit for the time he's been in there. Put back in there. He's been in custody since then.
The first one was in May, and then the next one the court found him guilty on was in July. So he would be owed whatever jail credit he's owed, but that contempt of court is consecutive, not only to each other, but to any sentence that he gets. So effectively, any jail credit he would get would be eaten up by the contempt of court and would not receive it for any eventual sentencing for the underlying case. So the people do feel it is necessary for him to be found guilty of contempt of court. Otherwise, there effectively is no punishment.
He's been found in contempt of court, and he will, on file number 24-0655, I'll give him credit time served on that file. File number 24-01407 FY, he has two separate violations for the May 24 violation. "90 days Ingham County Jail with credit." Fine.
May 23rd.
Yeah, I have a May 23rd.
All right, calculators. Okay, it's been 78 days since the May incident.
78 days for that incident. The other two violations are from July 18th. You get 93, sentenced to 93 days on each of those.
Thank you, Your Honor.
And each sentence will be served consecutively. Any additional matters for the record?
The only thing I'd like placed on the record, just make sure there is a clear record. Defense counsel asked me before the hearing if I'd be willing to waive the exam. I said I was. It's my understanding that it was the client's decision to run the examination today. Just make sure there's a clear record.
Any additional matters from the defense?
No, but that is accurate, Mr. Clerk.
You're all set.
Thank you, Your Honor.
And so Mr. Block's family remains seated in the courtroom.
There's going to be a waiver on Chapman today. Chapman. That's not a case.
Is Deaton here? I mean, is the witnesses on Deaton here?
No, Your Honor, they are not. We're going to be unable to proceed on that.
Yeah, I'm gonna have Mr. Pfeiffer supervise him real quick for this motion.
Absolutely.
On the record in the matter of the people of the state of Michigan versus Joshua Deaton, file number 24-00431, council appearance.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people. First, making a motion to practice pursuant to Michigan Court Rule number 8.120.
Motion granted.
Good morning, Your Honor. Stephen A. Freeman, Assistant Public Defender, appearing alongside Dean.
Okay, Mr. Deaton, today was the date that was scheduled for a preliminary examination for one count of assault with intent to do great bodily harm, less than murder or by strangulation, and a count two of assault and battery. Of the people do not have necessary witnesses, is that correct?
Yes, Your Honor, that is correct. The people will be unable to proceed.
Okay, counsel,
Motion to dismiss without, Your Honor, please.
a motion to dismiss without prejudice is granted, so that means that people do have the right to reissue the charge against you, okay? You understand that?
Yes, ma'am.
We'll get you a copy of dismissal in just a moment. He's not on GPS tether. Any additional matters for the record?
People would just object to the destruction of arrest records under MCL 764.26.
I put that on this because it's not an ollie.
As long as it's said into the record, I believe that's sufficient.
Counsel.
I did not hear.
Oh, repeat that for him.
Yes, people would object to the destruction of arrest records under MCL 764.26A.
Oh, I see. I have no comment. Thank you.
Okay, thank you. You're all set. I'll get you a copy of this in just a moment. You want any question?
No, that's why they hired me.
Yeah, there's people downstairs. My understanding is that we're waiving Chapman.
Yes.
Chapman can be brought up.
I believe we're seeking an adjournment on Wickwire, Your Honor, and we have a plea ready to go on board.
Wickwire, I don't even think it's here.
Yeah, Wickwire's not here, Your Honor. Yes, sir. We're requesting an adjournment on good cause grounds. My understanding is still on the county, it's Melanie Smith's case, but he's submitted a bunch of dates. We'll be with it.
And then Ms. Wanji had somebody that needs to be sentenced to. Not Wickwire, he's not here.
I'm
He's
just
up in
trying to
Clinton County, Your
schedule.
Honor.
Oh, wait, you want to set it for an exam or a plea?
Let's set it for example, please.
Okay.
Okay, I'm gonna go on the record on that one. On the record in the matter of the people of the state of Michigan versus Randy Wickwire, file number 23-00706 FY. Appearance, please.
Good morning, Your Honor. Case Mark Hearing, appearing on behalf of the people. Good morning, Your Honor. Jacob Starr, support of Assistant Public Defender here on behalf of Mr. Wickwire. Mr. Wickwire, Your Honor, is up in Clinton County. There were some issues with writs. He wasn't brought back to Eagan County Jail in time, apparently.
Okay, the court's gonna find good cause to go beyond the 21 days due to the lack of writ and have this matter reset.
September 26th at 9:30.
September 26th at 9:30.
Thank you, Your Honor. Thank you, Your Honor.
Your Honor,
Yes, ma'am.
with Newton, I had the waivers signed by the prosecutor and the defense. Did you want to go on the record on that? Or-
Yes, we have to have him brought up. He's downstairs.
No, Newton he bonded out. He's here in
Oh,
person.
on the record in the matter of the people of the state of Michigan. She put it back up there, but I don't know if she took it. Okay, people of the state of Michigan versus Joshua Newton, file number 24-02184, council appearance.
Morning, Your Honor. Case Mark Hearing, appearing on behalf of the people.
Yes, yeah, Michigan handling. An assistant public defender, Sarah Donnelly, on behalf of the defendant Joshua Newton, who is standing to my right.
Okay, let's see. There was a date set for a preliminary examination.
Your Honor, at this time, both parties are unconditionally waiving their right to a preliminary exam. We have signed the documentation and we're accepting that this will be found in the circuit court.
I do have a signature from the prosecution and from you, Ms. Donnelly, and your client. The people are waiving the exam.
Yes, Your Honor, that's correct.
Okay, and Mr. Newton, you understand that you have the right to have a preliminary examination in the circuit court. You have the right to require the prosecution put forth evidence that would establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You want to give up that right to examination?
Yes, ma'am.
Okay, anybody threatening you to do that?
No, ma'am.
Promises being made in exchange for you waiving your exam?
No, ma'am.
Do you know if there's an offer at all?
Currently, the offer is to be screened for 30th Circuit Penal Code.
Are you waiver to be freely and voluntarily given? Your matter will be bound over to the circuit court for a date of August 21st. That's the date they'll get the file from this court. You do not need to appear in court on that date unless for some reason Ms. Donnelly is making a motion for you to be rearranged at the circuit court, okay?
Yes, ma'am.
Your next court date then will, however, will be a pre-trial. Your attorney will be made aware of that. Do you have any questions?
No, ma'am.
Okay, you're still using your mom's number to contact you?
Yes, ma'am.
You're still at the address on Maple Street?
Yes, ma'am.
Any additional matters for the record?
Nothing further from the people. Thank you.
Not for defense.
Bond will continue. You're all set.
Let the block. Any, I see those.
Wait a minute.
I know. Yeah, I know her, she's just trying to finish up her notes.
I called Atkinson one thing ago. Is the Gordon?
You Gordon's
Yeah, so I called it, no, I called it earlier, y'all weren't ready, so now I'm going in order. Thirteen, 14, 15. We're all felony firearm.
Yeah.
Sixteen, which is okay. You said you had a plea ready?
Yes, Your Honor. Should be a no contest plea on the Gordon file.
On the record in the matter of the people of the state of Michigan versus Joseph Gordon, file number 24-02019, counsel appearance.
Good morning, Your Honor. Case Mark Aaron appearing on behalf of the people.
Well, Your Honor, Robert Roberts on behalf of Mr. Gordon. There's two cases that are called at the same time.
I see this 24-02115. State those set for preliminary examination. I do have a plea sheet. It says the people are offering for the defendant to plead no contest due to civil liability for amended count 1. File number 24-02115. Amending the count 1 in that file to an aggravated domestic violence. Is that correct?
Yes, Your Honor, that's my understanding.
That's correct.
Upon successful plea, the balance of this file and 24-02019 will be dismissed. There's a killer rule of no upfront jail. Defendant agrees to participate in battery intervention program. That's complete and accurate.
That's correct.
Also no objection to removal of tether and modifications of the no contact order to allow text communication regarding children if the court deems appropriate.
Yes, Your Honor, that's my understanding.
Yes, that is correct. And did you note no upfront jail?
There's a kilogram of no upfront jail that's between you and the prosecutor. But advise your client, I'm not a party to that agreement. You understand that?
We discussed it between.
Well, I'm asking him a question. Do you understand that?
Yes.
So kilogram, that's something that you all talked about. I'm deciding what your sentence is, and I'm not saying that you're not gonna get upfront jail. That's what you all are saying. You understand that?
You have a right to withdraw your
Yes.
plea if she
I'll-
decides to-
I will give you your right to withdraw your plea if I decide I'm gonna deviate from whatever your agreement is, which is, upfront jail. Okay,
Yeah, I'm not gonna give you.
well, you don't know that yet, but you'll have that right,
All right.
okay? Okay, and so a no contest plea is because of civil liability.
Yes, sure. Case involves a victim.
Well, then every victim can sue. Well, why don't we do all no contest pleas forever now?
My understanding, there's maybe a child involved. The basis for that.
The child was an alleged victim.
Not as an alleged. victim. Right, there might be some other stuff going on.
Okay. Raise your right hand. You solemnly swear or affirm the testimony you're going to give the truth and the whole truth under penalty of perjury.
Yes.
You can put your hand down. Okay, and so before you can accept this no contest plea, I have to know that you understand certain rights and that you're willing to give those rights up. The advice and rights is the information sheet. It has today's date on it. Is that your signature?
Yeah, you read it and I signed it.
Okay, and you understand the rights that are listed here?
Definitely.
Okay, and you're willing to give up each of those rights? You have the right to the presumption of innocence, so that means you're innocent until the prosecution can prove you guilty. You have the right to require them to prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt. So you want to give up your right to presumption of innocence?
Yes.
You have the right to remain silent at any trial and not have silence be used against you. You have the right to see, hear, or question in court any of the witnesses the prosecution intends to call against you, or you can subpoena witnesses that could testify on your behalf at your trial. You can present evidence at trial that you believe show a defense to the charges being brought against you. You can waive your right to silence and testify on your own behalf at trial, like all rights that you would have to give up today. And that's what you want to do?
Yes.
Anybody threatening you to give up those rights?
No.
Any promises being made to you in exchange for you giving up those rights and entering in no contest plea?
No.
Are you currently on probation or parole?
No.
And you understand that if a conviction is sustained against you, this could result in a conviction that you may need to report to your current or future employer? Sure you understood that?
Yes.
Okay. You also may have impact on travel or immigration status that you may be seeking. So you may decide later, you know what, I work hard, I want to go on vacation, and you think you're going to go out the country and they can deny the entry because of this conviction. You understand that?
Yes.
Okay. As to the amended count 1 and file number 20115 of aggravated domestic violence. How do you sleep?
No contest.
Okay. I have a police report here. And it's case number 24519045889, a date of incident allegedly being May 16, 2024 at the area.
That date is the date of the police report, but the incident in the paragraphs that are marked there, it tells the date.
Says the venue being 1337 Roselawn, City of Lansing, assault having occurred on May 13, 2024 at that address. It describes a domestic relationship between a Caitlin Brown and a Joseph Gordon. I haven't been in a romantic relationship approximately 5 years and living together at the address of 1337 Roselawn. They share a child together who was not present at the time of the assault. Let's see. Caitlin indicated or stated that Joseph assaulted her when she got back from Ohio, but she changed her story to the assault occurring on or following a Monday, May 13, 2024. Caitlin stated things were fine between the two of them all weekend until Monday. Caitlin stated that she was at home with the kids who were in Joseph's room and she was in the kids' room. Caitlin stated Joseph came home from work sometime in the early afternoon and they began to argue. Caitlin would not specify what the argument was over, but it led to Joseph grabbing her neck with both hands. Caitlin stated she was choked by Joseph for approximately 15 seconds. Caitlin stated she was able to breathe and did not lose conscience. And I'm assuming that this was not done in self-defense, although there's nothing in there. Any further factual basis?
No, Your Honor, people are satisfied with the factual basis. Thank you.
Defense satisfied with that factual basis as well.
The court is satisfied with the factual basis. I find the reason for no contest plea to be appropriate. I find your plea made freely, voluntarily, and intelligently. This matter is set for sentencing September 27th at 9 o'clock in the morning. You need to go downstairs to probation when you leave here so that you can check in so they can prepare the court with a pre-sentence investigation and a recommendation as to how you should be sentenced, okay? That was for him. I didn't hear him say yes.
Yes,
He doesn't have to go down to probation, you do.
yes.
Okay. Council, you can go through the police report. The files in 24-02019 will be dismissed for plea. Any additional matters for today's record?
Yes, Your Honor, just the things that were noted there on the plea form, also with the Heather, today, we're asking for that, there's agreement on that, as well as the ability to protect regarding the children.
Is the victim here?
Yes, she is.
So I can still get her, Your Honor?
So he had his hand raised. Did you have a question?
Just looking.
I wanted to know if I can give her the kids now. You know, like, you should go through, like, I work a lot. I want to know if I can give her the kids without violation, no type of thing, like, through my third party. Like, she wants the kids, like, she wants to be able to have the kids for like some time.
Okay, I'm not gonna get involved in the custody issue. I'm just gonna address whether or not she's okay with the communication. That's all I wanna.
And then that's the piece.
I don't, we don't do family matters here, so I don't wanna be involved in that. Okay. So she's not here, but the prosecution spoke to her about the removal of the no contact.
That's correct, Your Honor. I did speak with her earlier. She has been here all morning. I just saw her 10 minutes ago. I'm not sure where she went. She was in support of the modification for the no contact regarding the text communication with the children, and with the removal of the tether.
Right, and she's stationed for the record. please.
I'm sorry, Your Honor. Natalie may confirm. People.
I'll remove the GPS tether and peaceful contact is allowed. I'm not gonna tell you that that has to be text message, but just needs to be peaceful, okay?
Thank you, Your Honor.
Any additional matters for the record?
Nothing further from the people. Thank you.
Not for the defense. Thank you, Your Honor.
Thank you. I need Miss Donnelly's. Listen, is she in here? Who's the one with the AG?
Not.
I need not brought up. Yes, please.
I've got Chapman.
Okay, Chapman is here. On the record in the matter of the people of the state of Michigan versus Deontay Chapman, file number 24-02043, council appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Jacob Sartz, the fourth Assistant Public Defender here on behalf of Mr. Chapman. He's present at council today. Will be standing by.
Okay, how are you, Mr. Chapman? Today was the date that was set for a preliminary examination. How are we proceeding on this?
Your Honor, people prepared to proceed today. The victim is here and ready to testify, but the parties have agreed to a waiver of the matter unconditionally up to the circuit court.
Is there an offer?
There is not this time, Your Honor. The intention is a global resolution once all of his cases have reached the circuit court.
Okay, so Mr. Chapman, you understand your right to have a preliminary examination in this file in the district court.
Absolutely, Your Honor.
You understand your right to have a preliminary examination? And you understand that you have the right to require the prosecution put forth evidence that would establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that? And you wish to unconditionally waive your exam? Anybody threatening you to do that?
No more.
Any promises being made if you waive your exam? You understand it's an unconditional waiver, so if you get to circuit court and you don't like your offer, you can't change your mind and decide you want your exam. You understand that?
Yes, ma'am.
Your Honor, may.
Yes, please.
Thank you.
Find your waiver to be freely and voluntarily given. Your bind over date is August 21st. That's the date the circuit court will get the file from the district court. You do not need to appear in circuit court on that date unless Mr. Sartz is making a motion to have you rearranged, okay? Court date will be a pre-trial in circuit court. Your attorney will be made aware of that date, okay? If you have any questions?
No, ma'am. I'd be heard on, Your Honor.
Yes.
Thank you, Your Honor. This time, respectfully, on behalf of Mr. Chapman, I would request a reduction of the bond amount to a high personal recognizance bond with GPS tether monitoring, Your Honor. Respectfully, Mr. Chapman is not a flight risk. He has a stable place to stay in Flint. He has a lot of family support. He has members of his family who can help keep track of his location, keep tabs on him. He would, if he's released, seek employment. He concerns about safety for the community, safety for the complaining witness, Your Honor, can be addressed through a tether monitoring device, a GPS tether monitoring device, and perhaps curfew. And certainly he understands the importance that if he is released on this, complying with all of the court's orders and making sure that he shows up to his future court dates. Respectfully, he is indigent. So with the current cash surety amount, he would be unable to post that. We could have a lengthy process here up in circuit court. Well, I understand, Your Honor, that he does have other pending matters before Your Honor.
With the same victim.
With, yes, that's understood, Your Honor. However, still, I would respectfully request a reduction in his current amount now to personal cognizance bond. If he's able to resolve those other matters, Your Honor, then perhaps he would be released at that point and be in a position where he can provide additional assistance for his own defense while he's outside, while he's attempting to work and pursue some additional opportunities to better himself on the outside, Your Honor. Respectfully, to the best of my knowledge, prior to the instances here, 1223, the alleged instances at the end of December in 2022 and 2023, Mr. Chapman did not have much of a prior criminal history. His exposure prior to those dates was fairly minimal in terms of the criminal justice system, to the best of my knowledge. And he would have a very stable situation to return to in another part of the state, which also helps alleviate concerns, Your Honor, about accidental contact between Mr. Chapman and the complaining witness on this file, Your Honor. And his family is even here in support of him, and they would certainly be willing to provide the additional supervision if ordered to do so, Your Honor. Thank you.
I'm assuming counsel wants to respond.
Oh, yeah. The Flint address is new, seeing as how the last ones he gave were for his other victim's address in violation of no contact order he showed up to court with. I've spoken with the victim, Ms. Richardson, at length, and she has made it very clear to me this is one of many incidents by this defendant, both of a physically violent nature and a sexually violent nature. I do not believe that PR bond is appropriate at all in this matter. And as far as his family supporting him and helping to hold him accountable, his family were the ones who helped him get the other victim a new number to evade detection by the court and to help him evade the no contact order. So I do not trust that his family in any way, shape, or form will hold him accountable. I think that they'll try and tell him, please don't do wrong, but when push comes to shove, they will enable him, as they've already done, because technically they're accomplices to witness interference. So I believe $150,000 bond is particularly appropriate for this defendant, as it was when the court set it a few weeks ago.
I don't know how you make a bond motion for a personal recognizance bond when someone is on probation before the court for domestic violence for the same victim. That makes you ineligible for a personal recognizance bond.
Your Honor, I believe it would predate the terms of the allegations, respectively. But
what would predate the terms of the allegations?
Because these go back to 22 and 23.
It doesn't matter. He's still out on bond. He still appeared, and actually this I believe does have a date range from 2022 into 2023. But the issue, and I don't know how long I've had him on probation. I have a pending violation because of this, is what I know. And then I arraigned him on this on the 23rd.
His criminal history involves a HIDA dismissed case of weapons carrying concealed in 2018, and then you put him on probation for domestic violence in May of 2022. And then he commits this with the same victim while on probation in 2020.
So it did not predate this.
Well, my apologies, Your Honor. Apparently I had my dates mixed up. So
Correct.
that's on me, and I apologize for that. But
Then
in the alternative, then a low cash or surety bond if he's not eligible for a personal recognizance bond. Again, Your Honor, with plenty of supervision, with the tether.
He should have got plenty of supervision while he was on probation. I have here a bond recommendation that includes some other factors that the court considered when making their determination as to what the appropriate bond was. Not just the fact that I already had him on probation for assaultive action with the same victim, and that there was allegations, because I have another file with another victim that he supposedly brought to court with him when I took him into custody to arraign him. But I have here indications that obviously he was on either parole, probation, or had other pending matters. He has a history of violent behavior directed toward this victim, a history of threatening or harassing behavior toward the victim or witness that they were in an intimate relationship, that there's been threats to kill the victim or the victim's family, that he's engaged allegedly in stalking behavior, forced or threatened sexual acts are being alleged, an escalation of violence, attempts to isolate or prevent the victim from reporting. And that both allegedly, he committed both assaults in the presence of others and including the victim's infant child. And so the people actually requested a $500,000 cash surety bond with GPS tether and exclusion, but the court did not set a bond that high. I set a bond that I thought was appropriate, $150,000 cash surety with GPS tether under the circumstances. I don't believe that anything has warranted or changed, and it's not the responsibility of a family member to babysit an adult to follow court orders. And so if I put you on probation and the allegations that you're not following the orders, then, and he was appearing in court on a bond violation when I had to arraign him on this case, not appearing for arraignment on this case.
Understood, Your Honor,
So-
but these are still just allegations at this point. Mr. Chapman is presumed innocent. He might have to be potentially on bond for quite a lengthy period of time. We anticipate that we might have to try this case. And certainly, these are just allegations at this point from the prosecutor. Respectfully, he waived disciplinary examination today. So we don't have these proofs on the record. Again, these are just allegations as it relates to this case.
There were allegations when he was arraigned. The bond is appropriate, as said, and will continue. Any additional matters for the record?
No, Your Honor. Thank you.
Thank you. You're all set.
Thank you.
Yes.
Who did you want up next?
Ms. Donnelly's client on the state matter was not.
Yes.
Mr. Not. Slester, you ready on Slester? On the record in the matter of the people of the state of Michigan versus a trade.
My apologies. Sorry. Looked like something was happening that wasn't. That's why I asked. We're good, Your Honor.
Votes must be so. On the record of the matter of the people of the state of Michigan versus Trey Slester, file number 24-02126. Council appearance.
Good afternoon, Your Honor. Natalie McMiller on behalf of the people. Aaron Robinson, Assistant Public Defender to Mr. Sleazer.
Today is date set for a preliminary examination. How are we proceeding?
Proceeding to exam this.
So we have witnesses here.
We do, Your Honor. My intention, just so the court is aware, although now I'm not sure if this will happen, but I have two witnesses. I have Officer Nicholas McKeeby and Deputy Nabil Kanazi. I would ask the court if I could call Officer McKeeby out of order.
Okay, I didn't know. I was trying to see where we were with this. If I called this case at 9:15, that was, but Ms. Robinson was not here. I'm proceeding with all the in custodies first, so. If you can
I
wait.
apologize.
No problem. Okay, let's see. I don't see Ms. Wanji anymore. I'm gonna do Ms. Knott. We already took care of Wickwire. Do we know if Ms. Wanji's running when?
It's going to be a plea, Your Honor.
Okay.
And I believe Aldridge is in custody. He is in custody, yes.
We're running that one?
No, Your Honor, we don't have witnesses.
Okay, did you want to go and talk to him and I just sign a dismissal on that one, counsel, or do you want him brought up?
I can inform him, yes.
Let's see. Okay, on the record in the matter of the people of the state of Michigan versus Wendell Aldridge and file number 24-00221, counsel appearance.
Morning, Your Honor. Natalie Baker, on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Aldridge, who is downstairs in lockup.
Okay, and are you willing to waive his appearance for this limited?
I am, Judge.
Okay, so we are scheduled to proceed to exam. My understanding is we do not have necessary witnesses.
That is correct, Your Honor.
You would make a motion to dismiss, Judge.
Motion to dismiss is granted without prejudice.
Thank you.
Okay, that was done. I'll take that baby one. I need the sentence on the Bermudez. Mr. Starks left. Do we do that? Federal?
We did, Your Honor. We didn't have witnesses on that one either before dismissal.
Oh, I don't know why it's on the file here. Harvey Edwards, we already saw him. I don't think we called that one. We didn't call Harvey Edwards, did we?
Ms. Takeover was gonna go and check the hall, but we can call it now.
I think she said they don't have any witnesses. We'll call. Do you want to waive his appearance for this purpose?
Yeah, sure.
On the record in the matter of the people of the state of Michigan versus Harvey Edwards III, file number 24-01038. Council appearance.
Good afternoon, Your Honor. Natalie Baker, on behalf of the people.
Good afternoon, Your Honor. Jacob Starks, the fourth Assistant Public Defender here on behalf of Mr. Edwards. I'm gonna waive his appearance for this proceeding, Your Honor. Thank you.
Okay, today was the date that was scheduled for a preliminary examination. My understanding is that the necessary witnesses are not here.
That is correct, Your Honor.
That's what vote to dismiss, Your Honor. Thank you.
Motion to dismiss without prejudice is granted.
Thank you.
Thank you, Your Honor.
No problem. We'll get your copy in just a minute, Mr. Starks.
Thank you, Your Honor.
No problem. Okay, and so I'll do not, and then we can do Wanji has someone in custody if she's ready. Otherwise, I'll start your exam for Mrs. Slester. Mr. Slester. This is, you were Aldrich? No,
Those are the
Aldridge
originals.
oh, these are originals. She got the copies.
Okay.
Got it.
Here's the copies.
Okay, great, thank you.
Wait, this one doesn't even have a signature on it. Did I sign this one? Edward, did I sign it?
I handed it to you.
It doesn't have a signature on it.
Oh, you have to do that one again.
Well, you have I signed that one. If you have a copy, I'll just sign both. Edward?
Oh, yeah.
Just very trying to run this down to.
Oh, yes. Both of those friends.
Thank you, Your Honor.
No problem. Yes. Mr. Knott? Yes. On the record in the matter of the people of the state of Michigan versus Brandon Knott and file number 24-01941FY. Council manager appearances, please.
Christy Berta from the Attorney General's Office for the People.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Brandon Knott for a minute. While he appears separately to my right.
Thank you. Today was the date that was set as a exam, but we said we would treat it as another probable cause conference because the public defender had recently received discovery. How do we want to proceed on this?
Your Honor, it's my understanding today that we're willing to waive this unconditionally, the preliminary exam, and we would have a bond request. Yeah, that's correct.
Okay. Are the people waiving exam?
Yes, Your Honor.
So, Mr. Knott, you understand that you do have the right in this matter where you're being charged with 3 counts of failure to pay child support. You have the right to have a preliminary examination here in the district court. You understand the purpose of the exam?
Yes.
You have the right to require the Attorney General put forth evidence that would establish that they have sufficient probable cause that the crimes were committed and sufficient probable cause to charge you with the crimes. You understand that? Is anybody threatening you to waive your exam? Is there any promises made to you if you give up your right to exam?
No.
You understand that this waiver is unconditional.
Yes.
The bind over date is going to be August 21st. But you do not need to appear in court on August 21st unless your attorney makes a motion before then to have you rearranged on that date, okay? Otherwise, your next court date will be a pretrial in circuit court. Bond was set for statute. You wanted to address the bond.
Thank you, Your Honor. Yes.
I'm
we
sorry,
addressed
Your
it
Honor.
last week.
I'm sorry, didn't we just do this last week? My notes say we did it just last week.
We definitely did it last week, but I was anticipating there was going to be a different motion this time.
Okay.
Yes, Your Honor. Yes, we did request last week and the AG's office objected last time. I imagine they continue to object this time. I would just reiterate and also this time also point out that Mr. Knott's father, Rodney Knott, has been in court this whole time. He's very supportive of his son. He's been trying desperately to save Brandon's house. He's renting from in Nashville. And of course, he's facing hopefully not facing eviction, but moving his things and using the limited money that Brandon has to do it. Mr. Knott assures me that he does have assets. There's things that that he owns that he'll be able to sell and to raise the money to pay off his debt, but obviously he can't do that while in jail. Your Honor, at this time, the offer from the AG's office is entailed with him waiving up to circuit court. If he can pay off a certain amount of money, he can get a deal with them, Your Honor. So at this time, like I said, he doesn't have, he's been in custody since his arraignment. He doesn't have the exact amount to post. I think it's right now, it's set at $5,100. If he had it, he would have posted it. So Your Honor, we're asking for some sort of leniency. So to give him the opportunity so that he can pay off the debt and secure an offer.
Ms. Berta.
Your Honor, my position is the same. These are the same issues essentially that were brought up last week, that if he were out, he could work or he could make payments. This time it's he could sell items in his possession that could allow him to raise this.
He had that last week. I'm sorry. I just want to clarify that she's trying to call, like,
she did not disturb you when you were speaking.
Sorry.
I'll let you re-argue if you need to, but don't interrupt her, please.
Your Honor, my recollection from last week when we were here and addressing this issue was that he needed to get out to work to raise the funds. Today, what I'm hearing is that he needs to get out to sell objects that he owns to raise the money. My position hasn't changed. The statute requires 25%. This is not a new issue for him. There have been 9 prior show causes in family court where he was advised of the same concerns about his arrearages. He hasn't made full payments ever in this case. The arrearage today is up to $21,721.83. It is still accruing at $474 per month. So our position is that it should remain as ordered, and we would ask the court to deny her motion.
Thank you, Your Honor. In response, last week, it was my mistake that I didn't mention that there were assets. It's my understanding that, but those assets would need to be sold to accrue to by Mr. Knott or someone. It would need time to sell those assets. So when I mentioned
What kind of assets we talking about here?
Things like he earns money through scrap metal. So he has scrap metal at home. He has other tools and vehicles that you might be. You should have some cash too. My concern last week was that obviously it takes time to sell assets, and all he had was the money. So that's why I emphasized what he had on hand. But he does have assets. It's my understanding that he has tried to make payments. It's my understanding, I'll even bring it up. He had talks with the friend of the court back in February to set up payment arrangements and to try to set up the payment arrangement, and he is $500 a month. And
what happened? Did he set it up?
He did set up that 500. Well, he got picked up before he was able to make payments, but it's my understanding that from their own
February
documents
to now, what you're saying?
Yes, it's my own documents that he was making $500 payments last year, last one being November 16, 2023. There is a history up here of trying to make payments, and
what prevented him from making the payments? If he
well,
was trying.
He was incarcerated last year, so he was unable to make payments due to that. And then ever since his reincarceration, he's just been trying to catch up, which is, at this point, like I said, selling scrap metal is what he's. Go ahead.
Can I say something? I was evicted out of my home and had a PPO brought on me and had no means of even changing my clothes to go to work since 2017.
In 2017?
Yep, and it's taken me.
How long has this court order for child support been in place?
It started in 2017, Your Honor.
Okay, and so you was at least at the time that this warrant was signed, you had an arrearage of over $20,000. My understanding is that it's much higher than that now.
100.
And Your Honor, regarding the $500 payment plan, there was a payment of $500 made on August 31st of 23, and then 2 payments in November. Nothing in between and nothing since, other than a $200 payment in June.
Anytime I've made a payment arrangement with the front of the court, I've always met their obligation.
Well, the record doesn't show that you've been making those payments.
Not regular payments.
Well, then you didn't meet the obligation. The obligation is to pay the child support. You have an arrearage of over $20,000. The statute, the court didn't come up with this figure. The statute sets or indicates what your bond is to be set at in a child support failure to pay case. And the court can find good cause if it's shown to go beyond or to amend that. But saying that so he can go to work or so that he could sell property is not sufficient for good cause, because those were things that were available to him before he got picked up on these warrants. He could work and pay his child support. He could sell things and pay his child support, but he has not been doing that. And per the argument of the prosecution, they don't have a record of him being consistent. Even the statements he's made here in the court shows that he's not being consistent with making it. The court has no reason to believe that if we release him, that he's going to go and make a payment or be consistent with these payments. And the children need to be supported. I don't know how they're going to be supported otherwise, except for on the backs of the taxpayers. And so there's a reason why the statute is, sir, are you going to interrupt me one more time? Okay, thank you. There's the reason why the statute is set the way it is. And if the father is here in support, that's why I asked what kind of assets we're talking about. He doesn't need to get out to sell scrap metal. His father can sell the scrap metal, if that's the argument. So I'm not finding good cause based on those circumstances to lower his bond. Do you want to interrupt me one more time? Okay, a bond will continue $5,119.70 per statute, cash only. Any additional matters for the record?
No, Your Honor.
No, Your Honor.
You're all set.
Thank you.
Thank you. He's all set. Mr. Aldridge is all set. I think that I don't see Ms. Wanji. Oh, she's there. Ms. Wanji, I have to sentence somebody for her. So Bermudez, we can bring Bermudez up.
He was here earlier, just he left.
And he's not in custody?
No, he was released a few days ago.
Oh, so he left before being sentenced?
Yes.
Okay, so I'll issue a bench warrant. Did you have somebody else in custody?
Yes.
When?
Yes.
Are we running an exam on that?
Minute, please.
Okay, you can bring Wiin up. And then on the record, in the matter of the people of the state of Michigan versus Jace Buckley, file number 24-01572, and people of the state of Michigan versus Tavari McMiller, 24-01574. Council appearances, please.
Good afternoon, Your Honor. Natalie McMiller on behalf of the people.
Good afternoon, Mayor. Please, Honorable Court, Kareem Johnson, on behalf of Jace Buckley, P number 71988. Mr. Buckley is in the courtroom.
Good afternoon, Ronald Berry appearing on behalf of Tavari McMiller, who is in the courtroom as well. I've asked him just to say why we addressed up matter to be clear. That's okay with the court.
Correct. I called the case because of the indication that there was a matter that the court, the files, of course, are in my office, that the court needed to address. And so you can proceed with the issue. I don't know whose issue it is.
I don't bring the issue, Your Honor. I just wanted to address it now, just in case by Murphy's Law, if we wait around and then my issue winds up somehow resulting in an adjournment, we could do it now rather than have dozens of people wait around. I'm not asking for an adjournment. The issue is that Ms. Maycomber presented to me about 37 hours before we're scheduled for a prelim this morning, a CV and a few articles of somebody she proposes to utilize as an expert in the preliminary examination today. I did not, in accordance with 6.201, receive any kind of report rendered by that potential expert or a description of what his anticipated testimony would be as required by the court rules. We've been here for 3.5 hours. I still haven't got one. And what I think it's going to be is essentially just that body cameras look differently in the human eye. And he can talk about that. And my position is, well, if that's all it is, number one, I don't think that's within the purview of admission for the court to deem as an expert because it's not specialized knowledge. And so the court doesn't have to admit him as an expert in that field because it's common sense. It doesn't assist the trier of fact at all. We know body cameras can look different than the human eye. That wasn't satisfactory in this Maycomber. She just wants him to testify anyways. Well, I don't know, again, what the court's ruling on that would be, nor would I know what the court's opinion of it, me not having an opinion or an authored kind of suggestion of where he's going to go with his testimony.
Thank you, Your Honor. Your Honor, I did provide both the CV and the articles underlying the opinion for this expert to both defense counsel. I did send them an email letting them know that I intended to call him as an expert and that he would be testifying regarding the abilities and limitations of body worn cameras, which is the human perception. And again, along with the supporting research and case studies that would support his opinion. It's not simply just cameras look different than the eye. It's regarding, and I did explain this to Mr. Berry this morning, regarding the way that angles look and how it's how when you're looking at an angle through a body camera lens, that it is distorted. It's not as it appears. And that is something that this expert has specialized knowledge in. His CV outlines that and why he would be able to testify to those matters. I think that's very important, especially in this case when we're talking about looking at somebody else's body camera and where a person is placed and reviewing that camera. I think that's important for this court to be able to hear that information.
Again, just be willing to stipulate, it looks different. Nothing in what articles I've been given show to what extent it's different, nor its application to this case by this person. And frankly, I don't think the person is an expert. What's proffered as an expert is he's an expert in force science and comparing the human eye to video technology. And that's based upon going to getting a certification for a 24-hour, 29-hour certification through Force Science, which is an entity that teaches police officers in how to argue that their use of force in a particular situation that looks differently from the video was okay. That's like me saying, well, the Ron Berry Institute of Cops lie. I'm an expert, and therefore I can say, I call an expert to say how cops lie. Okay, we all understand cops are capable of lying, and we all understand body cameras can look a little bit different. There's no applied science. There's no data. There's no measurements. This expert isn't going to give us any of that. All he's going to say is it can look different from a fish lens. When it's rounded around the edges, it can make it look off. And I stipulate to that.
Yeah, that's completely inaccurate. The reports and the studies that I did provide to defense counsel, and I have a copy of the report like them as well, go into not only photographic details of how the perception is different, it goes into angles in the view of field, the way that a straight line would appear when you're looking at it through your eye, rather when you're looking at it through a wide lens or fisheye lens, which would not be in this case, it would be distorted or a turn. And how you cannot use a body camera in order to determine the distance or location of something. So that's
actually not accurate. Well, if that's his testimony.
It is, and it's included in the studies that I have provided to defense.
Okay, so it sounds like we're gonna have, this was all relative to the opening the proofs for the new evidence,
Which is the
correct?
second part I was gonna ask is if you could clarify, Ms. Montgomery, she has 6 or 7 witnesses here today as to what the limitation is for her.
We got 6 or 7 witnesses today.
Your Honor, given the fact that I didn't know exactly what Mr. Berry was going to challenge the witnesses on, I did have all the officers appear. I did not say I was going to be calling all of them. I didn't want to have to ask them to come back a second time.
Mr. Johnson, you didn't have an opportunity to respond. You also obviously got notice of the expert witness, correct?
No.
Oh, you did not.
But I think what happened was.
Yes.
No, I did not. Let me finish. I think the problem is, based on my communication with Mr. Berry last night, the email was sent to Kareem Johnson at gmail.com. My email address is kareemljohnson03@gmail.com. So based on what was forwarded to me, I didn't get it. I wasn't gonna say the prosecutor didn't try.
Matter will be adjourned.
But, okay.
No matter what, I don't see how we're gonna call all these witnesses, and he hasn't even gotten notice until right now.
Well, if the court, I'm prepared because.
Okay, so you don't have a problem with the fact that you.
No, because all the arguments, the court's gonna, my argument is the second part, right? I think this is outside the scope of what we were here for today, in terms of finishing the examination.
Yeah, I thought we were reopening the proofs. Well, I know I said I'm only reopening the proofs for the purpose of this new evidence that was brought forth, which was the body cam, correct? And so he's stipulating that he doesn't believe that to the issue of whether or not things appear the same from a body cam versus the eye.
Yeah, I'll
And so
stipulate.
your witness still needs to be called for what purpose?
Now, my understanding was that the purpose of reopening the proofs was to address the matter of the plain view and whether or not that the evidence that we are submitting to show the probable cause, which is the purpose of reopening to admit that evidence. Mr. Berry is arguing that that evidence then says that the objects or that the gun was not in plain view.
The gun that was under the seat.
Correct.
And that he said he saw with his plain eye, not with the body cam.
Correct.
Correct.
Yes, sure.
So why is the expert witness being brought in for that? I'm not following you.
The expert witness being brought in for that, Your Honor, so that I could argue essentially the parameters of what that would look like. Again, we've got Officer Brandenburg's body camera looking at Trooper Schaefer. And Mr. Berry and Mr. Johnson's arguments are that in watching Officer Brandenburg's body worn camera, it is clear upon all things that that Trooper Schaefer broached the plane of that car door.
Got it. Okay. Yep. And something about the tie. I mean, okay.
So this expert would be able to explain why that is not accurate and why looking at the body camera, or even if we were to do screen grabs, and why none of that would be accurate as to where the actual location would be because of the way the lens is distorted and rounded. It will not be an accurate depiction of where somebody was or where an object was when you're looking at it that way. Especially when we're looking at it in the sense.
Can he say it may not be accurate? No, it will not be accurate.
Correct. He's not done an analysis of the video at all.
Is that gonna be his testimony? I mean, I'm interested in hearing his testimony at this
Yeah,
point.
like I said, I
But,
stipulate to that how things can be different. He's done no analysis of this video at all. And one of the articles we even given, it says when you're doing a comparative analysis to a specific case, you need to recreate the scene and take measurements based upon the lens type, the resolution, the megapixels, the measurements. That hasn't been done, to my knowledge at least.
And so I'm assuming you're gonna go into all of these arguments as to.
I stipulate things can look different, but.
Okay. Well, to the extent that they're prepared to go today, and she's already got 7 witnesses here, I will try to get them in. Rather than having everybody come in. I was just advising them that I'm going to, you're waiting. Is this your client here? They've been waiting for a long time. I think I need to call them next. And then I have to do Slester, I believe. And so I was advising that they should go to lunch because I won't be calling them until after that. So.
Maybe I'm going the expert to look at the video and see if I was really standing here. Or
And perhaps-
I'll let you all discuss that off the record. I don't want to.
Perhaps you can write it an anticipated testimony.
Okay, sounds good. How many witnesses are on walls? How many witnesses do we have for walls?
For Walter, we have, people have 1 and defense has 1.
And then Slester? How many?
Well, 2.
2 witnesses.
Yes.
And then this was who?
This is not. Who? Not. No, I'm sorry, Wiin.
I was looking for Ms.
My
Wanji because I can't see out behind this computer. It's about, you definitely shouldn't be back until about 2:30.
Okay.
Yeah. Let's see, that's Wiin?
Yes.
Okay, let me do this one first. On the record in the matter of the people of the state of Michigan versus Terence Wiin, file number 23-00068 FY, council appearance.
Good afternoon, Your Honor, Natalie Maycomber on behalf of the people.
Yeah, for sure. Melanie, everyone, she for Mr. Wiin.
Okay, Mr. Wiin, how are you? Okay. Today's the date that was scheduled for a preliminary examination, but there's going to be a plea. It says that people are offering for you to plead to an amended count 1 of use of a narcotic, and upon successful plea, the habitual offender notice will be dismissed. There's a Killebrew agreement as to time served. That's complete and accurate as to your understanding of the plea offer. You want to accept it, sir? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Can you speak up louder? Thank you. I have an advice of rights of plea information sheet that has today's date on it. Whose signature is that? Could you read this? You understand the rights here? Are you willing to give up each of those rights today in order to plead guilty to use of narcotics? That means you're gonna give up your right to the presumption of innocence. So you're innocent until proven guilty, and you have the right to require the prosecution prove your guilt at a jury trial by proving each element of the charge being brought against you beyond a reasonable doubt. You understand that? You want to give up your presumption of innocence. You have the right to question or cross-examine any other witnesses that are called to testify against you. You have the right to remain silent and not have silence be used against you, or you can waive your silence at trial and testify on your own behalf. You also can subpoena witnesses that will testify for you and present evidence at trial that you believe show a defense to the charge being brought against you. All rights you want to give up, correct? I'm sorry?
Yes, ma'am.
And you're not on probation or parole, correct? You understand that if you plead guilty, this could result in a conviction that you may need to report to your job? Or if this could have impact on future travel plans or immigration that you may seek. So you might not be able to visit Canada in the future. You understand that?
Yes.
And you understanding that you still want to give up your rights. As to the amended count, actually it's, yeah, the amended count 1 of use of a controlled substance. How do you plead? Sorry?
Guilty.
Is that because you believe you're guilty? A factual basis, Ms. Wanji?
Thank you, Your Honor. Mr. Wiin, on January 7, 2022, where you had staff Malik in Dorchester, and visit received Nancy in the county. And at that time, you used a controlled substance, and that substance, controlled substance was cocaine, correct? And at the time that you used the controlled substance, you knew that it was cocaine. And did you have any valid prescription? And did you have on any other authority you used to obtain?
Any questions from the prosecution? The court is satisfied with the factual basis. I'll accept your plea and I find your plea to be freely, voluntarily, and intelligently. I'm going to advise you that there is a sentencing agreement. That's what the Killer Rule is. It's an agreement between you and the prosecutor. I'm not a party to that. So I have not decided that you're going to get credit time. So I'll decide that at the time of your sentencing. And so I am going to have you meet with probation so they can prepare the court with the pre-sentence report and investigation as to how you should be sentenced. And that will include you undergoing a substance abuse assessment first. You understand that? If at the time of your sentence, I decide to deviate from your agreement, which is for sentence to time served, then I will advise you of that. And you'll have the right to withdraw your plea if you'd like, okay? Do you have any questions? Your sentencing is going to be September 27th at 9 o'clock in the morning. Hold on, it's the 2,500, 10% still?
Yes, ma'am.
Or he has another matter pending?
That's the only matter that helps.
Okay, are we addressing bond today?
Yes, Your Honor. You know, my client is not a flight case. The bond amount is low for all purposes, but he is unable to post bond. That's why he's still in jail. And because he was charged with a felony and now he has pled to a misdemeanor, we would respectfully ask that he's bound in substitute to a PR bond and while looking to get out and get the substance abuse and assessment and mind his own, learning to become a better citizen.
Well, I think the issue that the court has is that he had a PR bond and then he didn't show up to court. What happened?
Young lady I was staying with you, she got into it.
She wouldn't give you your mail.
Didn't tell me nothing about my mail that came in.
Are you gonna blame it on your ex-girlfriend? Is that what you're doing? Because that's what you're doing. And let me tell you what, that's not gonna work because you were arraigned and you were given your next court date at your arraignment, not by mail. You still want to go with the excuse that it was her fault?
I thought that's what it was. I did a Zoom. In front of her at her house. And then the next thing,
you were arraigned January 7th, 2023. Your probable cause conference was for you to appear on January 19th, and your exam was scheduled for January 27th. You were given both those dates at the time of your arraignment. I'm inclined to believe that you were likely arraigned while in custody at the jail. They hand you your paperwork there. If I arraigned you, I asked you on the record, did you receive your paperwork? So you could show me on the screen that you received it. Either way, you received your next court date at that date. You did appear on the 19th via Zoom, and a probable cause conference was conducted, but you didn't come for the next court date, and you already had that date. And you would have been reminded of your next court date.
I didn't mind it for it.
You were given that date on January 7th, sir, that you needed to appear on the 19th and the 27th. We gave you a piece of paper with the dates in it. The other thing we gave you was a court-appointed attorney. And so when you didn't appear on July 27th, what did you believe happened with the court case? Did you think it evaporated? You forgot that you had a felony pending. You want me to believe that?
I didn't know what date it was.
Right, and so what efforts did you make? How old are you, sir? As a 58-year-old man, what efforts did you make to find out what your court case was when you couldn't remember? I'm sorry? You might as well be a flight risk if you're not gonna take any efforts to ensure your court date. All you gotta do is call your attorney. I lost my paperwork, or I didn't get any mail. I got a felony. When's my next court date? You lost the public defender's number?
She kept everything.
She kept your phone too?
I didn't have a phone.
You didn't have a phone? So you didn't call anybody for a year? Is that correct? I didn't hear your response, sir. Do you know where the public defender's office is? Sorry? You don't know where it is? It's down the street. You know you know where the local library is? Yeah, so you could have probably went and Googled if you needed to get in contact with your attorney, where the public defender's office was, no? Yeah, you see where I'm going with this? The excuses, they're not meaningful. You didn't even do anything to try. I don't think you forgot you had a felony pending. I can guarantee you, if I had a felony pending, I'm not gonna forget about it. What I'm gonna do is probably hope that what you was doing, hope that I don't get picked up on it. You didn't forget. And you can't blame it on whoever you was living with, that she tied your hands and you couldn't do anything about it. Nonetheless, you pled to a misdemeanor. What's your address?
947. Vincent Court.
What's your phone number?
Daughter's number. 706. 1517.
706, not 760?
706.
Okay, you gave the number in January 7th, you gave your daughter's number back then. You're using her phone? Oh, okay. And so that's the same phone you said you was using in 2023. So when you told me you didn't have a phone, you could have used your daughter's phone to find your attorney then, correct? Excuse me?
Yes, ma'am.
Okay, do you have your attorney's number now?
I'm gonna give him a call.
You're gonna give him your number?
Yes, gentlemen.
Okay, when you leave, I'm going to amend your bond to personal recognizance. You need to report in person to probation no later than Tuesday. Okay? Do you know where probation is? You speak so we can all hear you.
Right over here.
What's right over here mean?
On the other side of this building.
In this building, one floor down, the 5th floor. You need to report in person to probation because they need to prepare you for your pre-sentence interview, okay? If you don't report, then they're gonna tell me, and then I have to issue a bench warrant, and then you have to be remanded, and then you gotta sit in jail over something that's a misdemeanor, and you have an agreement for no further jail. You see how that would be stupid not to show up? Okay. When's your next court date, sir? The 27th, but if you show up on the 25th, at least we'll remind you. Your copy of your next court date's right there. Don't lose it. Don't let any girlfriends take your paperwork, okay? Do you have any questions? Any additional matters for the record?
No, you're not. Thank you.
Nothing, thank you.
You're all set, sir.
Thank you.
I'm going to take a 5-minute break and then we can call Walls. Okay, on the record in the matter of the people of the state of Michigan versus Dante Walls, file number 24-01271. Counsel.
Good afternoon, Your Honor. Nancy Newcomber on behalf of the people.
Good afternoon, Your Honor. Joseph Yang on behalf of Mr. Dante Walls, who is president to my right.
Okay, how are you, Mr. Walls? I'm doing well, thank you. Today's the date set for a preliminary examination and we are ready to proceed, correct?
That's correct, Your Honor.
The defense is ready to proceed, Your Honor.
Any preliminary matters?
I'm sorry.
Any preliminary matters?
No, Your Honor.
Just a general sequestration, but I believe just 2 officers today, so
Oh, there's 2 officers,
that's correct, Your Honor.
witnesses, okay. Sequestration is ordered. You can call your first witness.
Thank you, People call Officer Kristen Childs.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do.
You can have a seat. And just state your first and last name and spell both.
My first name is Christie, Christie. My last name is Childs, Chiles.
See.
Thank you, Your Honor. Ms. Childs, where are you employed? And in what capacity?
Police officer.
What does it mean to be a police officer for the Police Department? What do you do?
I work road patrol, respond to calls.
And how do you receive calls for service generally?
Dispatch.
Those come to a computer or a phone or something else for you?
They show up on a computer and they're dispatched.
Were you working on September 28th, 2023? And do you remember what shift you were working that day?
Afternoon shift.
And what does that mean? What hours?
From 3 to 1.
During your shift, did you have a reason to respond to 3436 North Waverly Road?
I did.
Is that in the city of Lansing?
Yes.
Ingham County, Michigan?
Yes.
What was the purpose of your response to that location on that date?
Objection, Your Honor, as to hearsay.
As to the dispatch,
Actually, the purpose of the response.
and to be an offer for the proof of this matters.
It is not, Your Honor.
Objection overruled.
Thank you, Your Honor.
What was the purpose of your response that day?
You were dispatched to weapons.
And do you have any other information given to you at the time that you were headed to that call?
Caller described an individual that was young.
Your Honor, is my hearsay objection still continuous, or this second question is?
No, there's no such thing as a continuous.
All right,
It's-
so-
We've already addressed that one, so this is a new objection
Hearsay, again, Your Honor, also lack of foundation
as
as
to
to what the caller said.
what a response to that.
Thank you, Your Honor. Your Honor, the information again is not being offered for its truth, being offered to show why the officers did what they did when they were responding to that location and why they responded to what they saw when they got on scene.
Have the objections overruled.
Such information was that there was an individual waving a gun around.
Can you speak up, please? That mic doesn't amplify the voice for me. So you need to speak just like you didn't have a mic.
Okay. The dispatch information was that there was an individual waving a gun around outside.
And were you provided any sort of description of this individual?
Yes.
And what was the prescription you were provided?
Black male wearing all gray.
You arrived on scene. Did you observe anybody that matched that general description?
I did.
And how many people did you observe that matched that description?
2.
What, when you very first arrived on scene, was the first thing that you remember seeing?
I observed an individual that was near the residence and then another individual that was near their car.
And both of these individuals matched the description that you were given by dispatch?
Yes.
Yeah,
And-
Your Honor, objection as to they match the description given by dispatch. That's hearsay. The matching part, the part that is saying that it matches the description, if this court allows that in as testimony, the court is allowing hearsay and that's.
It's not being offered for the proof of the matter asserted.
Thank
So
you,
that
Your Honor.
makes it not hearsay.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. And when you observed those individuals, what did you do as a result of observing those individuals?
We approached them.
You said,
Our investigation,
you said we, what do you mean?
myself and other officers.
Do you recall how many officers were with you that day? Approximately?
At least 3 others that I can recall.
And so there was 2 individuals, one near where you believe to be the residence and one near a vehicle. Did you respond to both individuals? Or did you respond to one of the two?
Walking up initially, yes, and then I was diverted to the individual that was standing next to the vehicle.
And how were you diverted to that person?
Officer Vanderwork had pointed out he needs to be detained because he matches the dispatch description.
And when you noticed the person by their vehicle, can you describe their demeanor as you were approaching them?
The demeanor was cooperative.
Can you describe what they were doing as far as their body placement and how they were positioned?
They were standing there and their hands were.
They were near a vehicle. Was the vehicle door open, closed, or something else?
The door was open.
And was the individual in front of the door or behind the door?
Behind the door.
So when you approached this individual, what did you do next?
I explained my reason for making contact with him. And then he was asked if he had any weapons, and he acknowledged that he did have a weapon.
Did he acknowledge that weapon was on his person?
Yes.
And what did you do as a result of that acknowledgement?
I took the bag off of him to recover my firearm that was inside.
Becky, I believe you said you took a bag off of him. How was that bag placed on his body?
It was like a crossbody.
And do you recall what that bag looked like?
It was black.
And you took that bag. What did you do with that bag?
I held on to it so I could secure the firearm.
And where was the firearm?
Inside the bag.
And how did you know the firearm was inside the bag? Was the bag open, closed, or something else when you grabbed the bag? Do you recall?
I recall, I believe it was closed.
And did you open that bag?
I did.
Why did you open the bag?
To determine if there was a weapon inside.
When you picked up the bag, did it, I guess, have you picked up bags that have had firearms in them before?
Yes.
And do you know firearms to be a certain weight-ish?
Yes.
And based on your knowledge of firearms, did you believe there to be a firearm inside of the bag that was on his person? Yes. Again, that's also because of the statement he made. Yes. And when you observed that firearm inside the bag, do you remember what kind of firearm that was?
Yes, it was a Glock 22.
Is that a handgun, a pistol, handgun or a long gun or something else? A handgun. Okay, thank you. Were you able to identify the person that had the bag on them that contained that firearm? And who could you identify that person as?
He identified himself as Dante.
Were you able to confirm his identity at any point? Yes. How does that happen?
He verbally told me his name, and then I ran him in our Wiin system, which brought up his photo.
Would you recognize this person if you saw him again in the courtroom today? I do. Can you describe where he's sitting in an article this morning?
He was sitting in front of us, and he's wearing black.
Has the record reflect identification of the defendant?
Any objection to ID?
For purposes of the freedom.
So noted.
And one last question, Officer Charles, when you first approached the defendant and you saw the bag on this person, could you see that firearm? No. And when you first took the bag off of him, did you see the firearm at that point before you opened the bag?
No.
Completely concealed? Now, how long into your interaction did the defendant admit to having a firearm on this person?
I don't know exactly how long. I think I was able to have a couple sentences with him. Explaining the reason for the contact before he was asked.
That was essentially the first question asked of him?
Yes.
And at that point that you had made contact with the defendant, it said there was a second individual. Did you see a gun on that individual at all when you were approaching the defendant?
No.
Did you see a gun anywhere around at that point?
No.
So at that point, did you know which of the two individuals the dispatch information may have been relaying about?
No.
So we're still investigating that?
Yes.
Thank you, Your Honor. Charles, I want to take you kind of in chronological order. Did you go straight to the scene, or did you observe prior to going to the scene? Like, were you parked somewhere else observing the parking lot before you went there?
From what I recall, I do believe that we were parked nearby observing.
So you guys were observing, is that correct?
Yes.
And that's when you observed both individuals?
From what I recall, I think it was another officer that like called out over the radio or was like doing observations, and I was like nearby too.
Okay, so when you responded, you actually were responding to the other individual first, when you first walked up, is that correct? You were going towards that other individual first, correct? That was more hostile.
I would say yes.
And then that's when you were redirected to Mr. Walls, correct? All right. And earlier you had said some specific statements that the officer had said to you that they matched the description. Isn't it true that basically they just said to detain that person? They didn't give you any other reason besides that, just to detain that person? You recall that?
Yeah, so he physically brought our attention to Dante
Correct.
by pointing.
Correct, but
And
he
then
didn't
I
say.
could observe that he matched the description that was provided by dispatch.
Okay. And then when you approached him, didn't you approach him with Officer Malik?
Yes.
Okay. And when you guys approached him, was he free to leave at that point?
No.
Okay. And actually, you guys kind of cornered him in his door, correct? So his door's open, kind of creates a triangle, and you're on one side, Officer Malik is on the other, correct?
So his door is the door to a vehicle?
Door to a vehicle, correct. So his door to his vehicle, you are on one side of, and then Officer Malik's on the other side, pretty much blocking any exit that he could have, correct?
So yes, we were that in position.
All right.
There's two of us in a small door.
So just to confirm, at that point, he was not free to leave, correct?
Well, we needed to make contact with him in order to do the investigation.
So was he detained at that time? So he could have left at that time if he wanted to?
No.
Okay, so let me ask again, was he detained at that time? By the time, okay. And is it true that Officer Malik actually put his hand on Mr. Walls before you guys started asking him about the gun?
I can't speak on what Officer Malik did. I don't recall.
Okay, if I showed you a still shot of your body cam, would that help?
Are you saying that you can't speak on it because you can't remember?
I don't remember what Officer Malik did.
Or did you ever see what Officer Malik did?
I know that he was standing right next to me during the interaction, but as far as his hand placement, I can't remember that from a year ago without referencing my body.
Counsel, you stood up.
Your Honor, I was just going to suggest that I understand Mr. Yang is also going to introduce the body camera that may get better so that the photo wouldn't tell the time in which sequence is happening.
Understood. So did you have a body cam on that day?
I did.
And you submitted that body cam as evidence to the people, is that correct?
Yes.
All right. I have what's marked as defense proposed exhibit A, which has 3 files, one of which is the body cam for Officer Childs.
You said the proposal exhibit 3?
A as an apple.
Oh,
Your
A
Honor.
as an apple?
Yes.
Okay. And you're seeking to admit that?
I'm seeking to admit it. Admit the Officer Childs body cam video as evidence.
Any objection?
No, Your Honor.
Defense A is admitted.
Thank you, Your Honor. My understanding is you prefer sharing on Zoom or a direct connection to the HDMI.
The direct connection just never seems to work in here, so I made you co-host already.
I will try my best to, if my internet connection is fast. Charles, I'm gonna play. I'm moving on. Okay. Officer Charles, I'm going to show you this video, and I want you to Will that mute the video?
Yeah, she's muted.
Yeah, okay, yeah, so I didn't, yeah, so I'll just make sure that the audio is on. Okay. So I'm gonna play what's been admitted as your body cam view. All right, I'm gonna play this from the first part of this. Can you kind of narrate what's going on here?
I'm driving.
Let's stop it right there. Is this where you say another officer directs you in that direction? Okay. So at this point, Mr. Walls is standing where his door is open, but still outside his vehicle. Is that correct?
Yes.
All right. And you are to the left of him. Is that correct? And then the other officer is to the right of him. Is that correct? Or behind him?
To the right of me.
To the right of you, kind of behind him on his left side, correct? Just to confirm, at this point, or your testimony is what he was detained. He was not free to leave. Is that correct?
Correct.
All right.
Did you click share sound when you shared the video? If not, you have to exit out of share and then start over, where there should be a little box for quick share sound.
That's why we're out here, and that's why we come out.
I work for his mom. Do you have any guns on you? I carry.
So at this point, he's detained. Is that correct?
Yes.
Even the officer's hand is on him, so he's really not free to leave, correct?
Correct.
Did you Mirandize him at this time?
No,
Okay. And you started asking him questions even though you did not Mirandize him, correct?
I did not ask him that question.
Okay, but so the other officer started asking questions about any items that he may or may not have on him while he was detained. Is that correct?
Yes.
All right. And this is your body cam, correct?
Yes.
All right. And then moving forward from this, Mr. Walsh tells you that he has a firearm on this person, correct?
Yeah.
And that's when you take the firearm off.
Yeah.
And just to confirm, prior to, once he was detained, no Mirandize was provided to him to this point, correct?
Yes.
Did you Mirandize him subsequently afterwards?
Objection on as to relevance. What's the relevance?
No, I will withdraw that question.
Thank you.
Your Honor, let me rephrase that. He was still further detained from this, is that correct? Was he put into the back of the patrol car? And at that point, did you Mirandize him?
I brought him back to my patrol car, and at that point, I Mirandized him
And what would be the reason to Mirandize him?
because I was gonna ask him further questions about doing stuff.
Okay. Because he was in custody or was he detained at that time, correct? What color was the gun that was found on him?
So what?
Paint.
In your opinion, could it be confused for any other color than pink?
Objection, Your Honor, as to relevance.
What's the relevance?
Your Honor, the earlier I had objected to as to the firearm that was observed by the 911 caller as to hearsay. And so I'm not sure how much leeway this court is gonna allow as far as of that call to come in as hearsay or not hearsay. I was trying to establish the firearm and the color of the firearm that Mr. Walls has.
I don't even remember if they described the color when she asked her about it, but that wasn't let in for the truth of the matter asserted.
Thank you, Your Honor. The questions.
Thank you very briefly, Your Honor. Officer Charles, when you first initiate contact with the defendant, at that time, yes, you were still continuing your investigation as to the call.
Yes.
Once you learned that he had a firearm on him, did you believe that he had committed a crime?
Yes.
And was that based on the firearm being concealed?
Yes.
And so at that point, was Mr. Walls under arrest?
Yes.
And then you Mirandized him?
Yes.
Then you asked him more questions after that?
I have a question. When you originally testified on your direct, you indicated that he was wearing a bag. I don't think I saw a bag on the video.
Yeah,
Yes, there's a question. Yes, there's a question. Had the bag been removed at that point in the video?
Play it back.
Yeah, maybe we gotta play, because I didn't see him with a bag on. Sorry.
On my computer is not topical when it's sharing this job.
Is it because of the internet?
Yeah, I'm connected to my own hotspot here.
You're not able to get on the Wi-Fi here?
It was even slower when I pressed it.
My gun that's in my bag, but I just got here.
We're gonna take the bag off real quick. Okay,
Just till we figure out what's going on.
Okay.
Yeah, I just got here. Like I'm not even lying.
Okay.
Put him on the ground. I'm just gonna hold on to your hand. I swear to God, it was not me.
Relax. Stop resisting.
Okay, thank you. Any other questions for this witness? This witness may be excused. You can call your next witness.
You're on the people rest.
Grounds the defense called Officer Vanderwork.
Okay. Oh, okay. All right. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, ma'am.
Thank you. You can have a seat. State your first and last name and spell both.
Yes, it's Officer Zachariah Vanderwerf. First name is spelled Zachariah. Last of Vanderwerf, that's going to be Vanderwerf.
Thank you, Your Honor. Officer Vanderwerf, where are you employed?
With the city of Lansing.
Okay, and what department or?
The police department.
All right, thank you. Were you on duty on or about September 28th of 2023?
Yes.
Do you remember a call that you had that day?
I do.
All right, and you responded to that call, correct?
I did.
All right, and based on the nature of the call, you didn't immediately respond to the specific area, is that correct?
As far as like, did I drive directly
To
up
the
to the
parking lot,
scene?
correct.
I did not.
All right, what did you do to respond to that call? What did you do first?
So I found a parking lot that was just to the west of the area that we received the call. I used my binoculars to do surveillance prior to going on scene.
Okay, and what did you observe while you were using your binoculars?
So I observed two people standing out front of the specific building that we were called to. It was near a handicap parking sign, and I saw two individuals standing next to each other.
All right, and did you observe any crimes being committed while you were observing from across the street?
No.
Okay, and did you see any firearms at all from across the street there?
I did not.
All right, and what did you do eventually? What did you do? Sorry, how long did you observe from that position?
Oh, I can't recall how long I was there for.
5 minutes, 10 minutes, 30 minutes?
Probably at least 5.
At least 5 minutes?
Probably.
And in those 5 minutes, no crimes were observed, is that correct?
I did not observe any crimes.
Okay, were there other officers there that were in that type of position as well?
I believe I was the only other one other than my recruit that was in the car with me.
Okay. And so there were no crimes that were observed. What did you do next?
So basically, I just provided the information that I had to other officers responding to the area. So I observed two individuals. One was Mr. Walls and the other was Mr. Williams. Mr. Williams was wearing a gray shirt and gray sweatpants as described in the call. And then Mr. Walls was wearing a gray t-shirt, gray hooded sweatshirt, and then had a like a crossbody shoulder bag.
So based on your observations, Mr. Williams is the one that matched the description, is that correct?
Well, they both were wearing gray.
Okay, but were there other descriptions for him, for the caller as well?
So the caller said gray t-shirt, gray sweatpants.
Okay, did they describe the demeanor of the person that they were observing?
They did say that they were yelling and acting crazy.
Okay, and in your observations, was Mr. Williams doing that at all during your observations at all?
So Mr. Williams was talking with his hands a lot and he appeared to be agitated about something.
Okay, and did you assist, who did you assist to arrest that day?
So I assisted to arrest Mr. Williams just due to the level of his agitation when we showed up on scene.
Okay, did you assist with Mr. Walls at all that day?
I did not.
All right, when you assisted in the arrest of Mr. Williams, did you find a firearm on him at all?
No.
Okay. And did you guys do a subsequent search of his home as well?
Yeah, I believe there was a.
Were you part of that search at all?
I was.
Okay, were there any firearms found there?
No.
Okay. Do you recall redirecting officers towards Mr. Walls?
Yes.
Okay. Did you author a report after the incident?
I'm sorry, say again.
Did you author a police report after the incident?
I don't recall authoring a report.
I'm sorry, authoring. Did you write a police report?
Did I write a police report? Yes, I wrote a police report. Yeah.
All right. And do you recall your description of the difference in the description between Mr. Williams and Mr. Walls at all?
Yeah, so the way that I described Mr. Walls in that was that he was wearing a gray t-shirt and then the gray hooded sweatshirt over the t-shirt and then had the crossbody shoulder bag on, which I believe is black in color. And then for Mr. Williams, it was a dark gray long sleeve shirt and then light gray sweatpants.
Do you remember talking about which one matched the description more?
Yeah, I think just based on the agitation and just how I was observing that person, what he was doing with his hand gestures, I definitely describe Mr. Williams as the one that we believe was probably the one that they called on. Yeah.
Just to verify, did you have any subsequent contact with Mr. Walls after leaving the scene at all?
I don't recall any other contact.
No further questions, John?
Cross-exam.
All right, 1 moment.
So Vanderwork, you said that when you first received the call, were you on scene at that point or in that west parking lot at that point when you first received the call?
Yeah, so when we first received this call, I responded to that parking lot just to the west of the scene.
So you responded to that, you weren't sitting there when the call came in?
No,
And was there some response time to get to that parking lot?
yes,
And when you got to that parking lot, you said you used binoculars to observe?
yes.
Why didn't you just go from the scene right away?
Because I was waiting for additional units, so it takes time to get more police there, and that's due to the officer safety issues with somebody potentially having a firearm. It's safer to wait for more units to come.
Is it in accordance with your policies and procedures of the Lansing Police Department?
Yes,
And you said that the description that you were given was gray t-shirt and gray sweatpants.
yes,
And do you recall when you were observing with binoculars, could you see Mr. Wall's pants at that time?
I could not see his pants, no.
And did you later learn what color pants Mr. Walls had?
I never saw what kind of pants he had on.
Then if we could play Defense Exhibit A. While he gets that around, Officer Vanderwerf, what type of shirt did the other party have, Mr. Williams?
Mr. Williams had a dark gray long sleeve shirt.
And again, the dispatch info was a t-shirt.
Yeah, gray t-shirt.
At the time that you responded, did you have any way to know which of those two individuals actually was the individual reported in?
No, I had no way of knowing.
How long have you been a police officer?
7 years.
In your time in responding to calls in those 7 years, is it fair to say that you get a call about somebody who's being erratic or who's being agitated, that when you respond, they may be calm at that time?
Oh, yeah.
Is it fair to say that you responded to calls and the person has had a gun pointed at them and they are now erratic?
Yes.
Officer Vanderwerf, can you tell, looking at this, does it appear that Mr. Walls has gray pants on?
Yes, it appears he does.
And that would be consistent with the description that you were given originally?
Yes.
Can you put that a little bit further? I just want to see what color t-shirt or shirt he's wearing. Continue.
Thank you, Your Honor. And finally, you stated that the defendant or Mr. Walls had a crossbody bag.
Yes.
Was that important to you?
Yes.
Why?
So based on my training and experience in dealing with subject with firearms, the trend is right now that people are carrying firearms in those bags.
And did that further lead you to believe that this person may be the person that had waved that firearm around at that time?
Yes.
Is that why you asked Officer Childs and Officer Malik to detain Mr. Walls at that time?
Yes.
Nothing further.
You direct.
Just briefly, Your Honor, you said in your training experience, crossbody bags are where firearms are carried, is that correct?
Yeah, that's the trend.
That's the trend, but it's not always the fact, is that correct?
Yeah, not always.
Not always, it could be anything in there besides a firearm.
Yes.
Okay, all right, just. No further questions, Your Honor.
Thank you, Officer Vanderwerf, you to be excused.
Thank you, ma'am.
Your next witness? Sorry, defense?
The defense has no further questions, Your Honor.
Okay, argument.
Thank you, Your Honor. Based on the testimony by both Officer Childs and Officer Vanderwerf, we heard that they responded to the location 3436 North Waverly Road in the city of Lansing. And in response to a call, the black male wearing a gray t-shirt, gray pants, and a gun around. And when officers arrived, they actually observed two individuals that could have matched that description, and unaware of which individual would have been the individual carrying that firearm. They detained both. Based on Officer Childs' testimony today, Your Honor, that when they approached Mr. Walls and told them why they were approaching him, asked if he had a firearm on him, he stated that he did have his firearm on him and in the bag that he was carrying on his person. At that time, Your Honor, it is at that time that Mr. Walls was then placed under arrest, taken back to the patrol vehicle, Mirandized, and then asked further questions about that firearm. However, prior to that point, while he was detained, he was not under arrest, and therefore Miranda would not apply to the initial questions of the officer investigating the crime. Additionally, Your Honor, the observation of Officer Vanderwerf is that when he finally does respond, and there is some response time to get to that parking lot in which he's observing both individuals, that at that point he sees Mr. Walls, who's being more calm, and Mr. Williams, who's being more agitated, but did not see a gun in that moment. And we heard Officer Vanderwerf state that there are times when he has responded to calls in which the agitated party that was called in has since calmed down, and calls in which somebody has had a firearm waved at them or pointed at them, and now that person is now agitated. And so it was fair for him to believe that either of those persons who matched the description based on the clothing and the physical description could have been either of those individuals. Based on those concerns, we asked the brands over the charge of the complaint.
Which officer testified as to whether or not the defendant had a concealed weapon?
Officer Childs, Your Honor. She testified that in the bag that was on his person, that she could not see the firearm prior to opening the bag. She removed the bag from his person.
No, whether did he have a CPL?
And neither officer testified to that, because that would be a defense and not one that had been raised.
Oh.
It would be an affirmative defense as opposed to an element of it.
Thank you. You can proceed to argument.
Thank you, Your Honor. First, I'll just start with the beginning. Again, just want to talk about the call about the truth of the matter asserted. It's just the way I look at it is that officers were called, they respond to a scene. As far as what matches, doesn't match, that is hearsay and a lack of foundation. The caller's observation, we don't know what they were observing, what they did or didn't observe, or if they were just making this up. We don't know that. So therefore, that's why I bring the court's attention to my objection as to the truth of the matter asserted when officers say what they observed matched the call. That is bringing in the hearsay of the call itself. So therefore, Officer Vanderwerf testified that he came to the scene, he observed for about 5 minutes is what he recalled, did not see any crimes committed at all. He did not see anything committed, but they still proceeded to make contact with these two individuals. They made contact with these two individuals, Officer Childs and Officer Childs and Officer Malik basically detained Mr. Walls in the corner of his car there. He was not free to leave. Miranda applies then. Miranda applies when he is not free to leave, not necessarily when he's arrested. Anybody can be detained. Miranda applies at detention, not at arrest, because you can be questioned prior to that and you can make statements that are against your interest. That's the 5th and 6th Amendment, right? And Miranda applies at detention. And as you see in the freeze frame here, he's detained. Hands are actually on Mr. Walls at this time. And the question about the gun was asked. They didn't ask where
Does he have any guns on him? So what you're saying is that the officers can't do a traffic stop and ask if there are any guns unless they Mirandize, or they can't do a brief detention unless they Mirandize before they find out if this person, the subject, is carrying a firearm?
Your Honor,
that was a direct question. Is that what you're saying, yes or no?
That they can't ask questions?
They can't ask about whether or not the person has a weapon on them.
Your Honor, that wasn't and something that was brought as far as officer safety goes.
Excuse me?
That was not something brought.
You didn't answer my question. You're giving further argument. Are you saying that officers cannot ask questions about whether or not the subject or potential suspect is carrying a firearm or weapon without Mirandizing them?
Officers can ask anybody any question they want to ask.
Yeah, that, I didn't ask you that.
But can they? Yes, they can ask somebody if they have a weapon on the ground.
Without Mirandizing them.
That is correct.
Okay, so your argument here is what?
My argument is that they had him detained and asked him if he had a firearm on him.
Okay.
Therefore, because that statement is testamentary and is against his interest of having a firearm on him when he's detained, that Miranda applies, and therefore that statement telling them that he had a firearm is not admissible because Miranda was not provided to him.
But you just said that they can ask questions about whether or not there's a firearm or weapon without Mirandizing them.
That's correct. Officers can ask questions all the time, but Miranda is something that they are required to provide. If
No,
they're going to ask questions.
that's not what I said. I don't have to keep telling me the officers can ask questions all the time. That's not what I said. You just said in response to my question that an officer can question a subject about whether or not they have a weapon or a firearm on them during a detention without Mirandizing them.
Can they ask them? Yes, I think it violates Miranda. What I'm saying, I'm answering your question by
What law do you have, or what case law do you have that supports that that's a violation, not what you think?
Your Honor, Miranda in general, when you are detained, any in custody questioning, that is in custody questioning. Miranda
versus they're detaining someone and they in response to a call, and you don't think that they have a concern about officer safety, even though this officer Vanderwork just testified that he sat back and observed for 5 minutes with binoculars due to officer safety.
He sat back and observed nothing for 5 minutes.
Well, he observed, he didn't see anything while he was there during the observation, but he took precautions first, at least for his testimony, to make observation while he waited for other units to come. And when asked why he did that, he said for officer safety due to the nature of the dispatch. So why would you think that he needs to Mirandize, or anyone needs Mirandize before they ask about weapons for officer safety?
I understand that an exception for Miranda is officer safety if there's a pat down or something of that nature, but
your witness brought in the issue of officer safety.
Your Honor, the issue is the officers went to him. It wasn't like they observed anything else. And
yeah, but your
to,
officer brought in the issue of officer safety.
But this goes to the hearsay of the call. There was the lack of foundation. If the call that comes in needs, if the officers are saying that it matches, that's testimony they're trying to bring in, that it matched, and that's why they did what they did.
They did what they did. They reported to the scene because of the dispatch. That's why the information was being brought in. So the information does get to come in for that purpose. What I'm saying is not hearsay, because it's not being brought in to prove the truth of the matter asserted. No one, that doesn't mean that the information is not brought in. So it was brought in. It's just you don't get to use the hearsay objection because they're not bringing it in for the truth of the matter asserted. They're explaining why in the world did they report to this location at this time, and they're allowed to do that.
Correct.
To explain why they got to that point. And so when they got to that point, now they're bringing testimony as to what they did when they got there. And so even if you were going to rely on that of that objection as to her questions, you then later call the witness, and then you start asking questions about the dispatch and what they wanted. You just blew the objection because you opened the door on your own cross or your own witness. Any other argument?
Yes, Your Honor. As to the illegal search and seizure of my client, again, going down to there was not probable cause because the officers observed him for 5 minutes. There was no independent crime that was observed by the officers, and they responded to the scene. So therefore, they searched him illegally, in addition to the violation of Miranda with 5th and 6th Amendments. As to the 911 call, again, the confrontation clause, to me, the 6th Amendment, there's a lack of foundation of that call coming in. as far as the matching of the suspects. Therefore, I'd ask that the case be dismissed as Mr. Walls was wrongfully detained, wrongfully searched, was not provided Miranda. Thank you, Your Honor.
Any argument?
And the only thing I will say in regards to that is that the search only happens after the defendant says, yes, I have my firearm on me. At that point is when the bag is removed from his person, the bag is opened and the firearm is discovered. So absolutely, the officers were under the impression that he was committing a crime when he states he had a firearm on him at that point. I think the court hit it right on the head when it comes to when they are responding to a scene and there's an officer safety concern. Terry applies, are allowed to do a Terry pat. Before they even do that, they ask this defendant, do you have anything on you? He admits that he does. And once that admission happens, it's not a custodial interrogation. It's the officers investigating the crime that they're responding to. Once that admission happens, they absolutely have the ability to remove that bag from this person, look in that bag and find the firearm. So then we'd ask you to find this over.
Okay, today was the date set for preliminary examination. I have one count of weapons carrying concealed. And the burden is on the prosecution to establish probable cause that a crime was committed and probable cause that you committed the crime. This is not a trial. They don't have to prove each element beyond a reasonable doubt. It's just more than mere suspicion. And so we had first the testimony of Officer Christy Childs, who testified that on or about September 28, 2023, at the area of 3436 Waverly Road, that she responded along with some other units for a dispatch. And the dispatch was in regards to a weapons complaint. And there was a description given of a black male wearing all gray, is what her testimony was. And she advised or testified that when she arrived, she saw two individuals, one that was near a residence, one that was near a car, that Officer Vanderwork pointed out a suspect to be detained. And she identified that suspect to be the person in the court today as Dante Walls. And the suspect was questioned about whether or not he had any weapons. He said yes, he had a weapon on him. She testified that he was wearing a black crossbody bag with gray sweatpants, that the officer removed the bag, opened it, and located a firearm. She did give some testimony about her training and experience and about whether or not she had found or held bags with firearms in it. I always find that kind of questioning funny because anything could be in a bag and weigh it down. So I don't know that you can have training and experience to tell you exactly what's in a bag, but under the circumstances, she did testify that she was told that the person had a weapon on them in the bag and that the weapon was located. Defense called testimony or called Officer Zachariah Vanderwork for testimony. And he testified that based on the same dispatch to the area of 3436 Waverly Road, venue in this court appropriate, that he responded, but he didn't go immediately to the location, that he stopped off into a parking lot west of the area to use binoculars to observe the location. He indicated that he did that because of officer safety, that because of the nature of the dispatch, that he needed to, it was wise for him to wait for additional units and to observe to see what was going on. He testified that he did not observe any crimes being committed during the 5-minute period that he made observation. He provided information that the dispatch indicated that the subject was wearing a gray t-shirt and gray sweatpants. Defense has made an objection multiple times as to the hearsay nature of that testimony, but then the defense asked a question directly to his own witness about what the dispatch said. So you open the door for that testimony to come in even outside of your objection. But the court had already made a ruling that the initial dispatch information could be brought in because it was not being offered for the truth of the matter asserted, but it was being offered to explain why the officers did what they did, which was report to the scene of the incident and what they were looking for. Again, on the defense case or questioning The officer testified that the subject or suspect was said to have been wearing gray t-shirt and gray sweatshirt, which is very different from what, let me strike that, not very different, but slightly different from what the first witness testified, because the first witness testimony was that it was a Black male wearing gray, not specifically t-shirt and sweatpants. And he, being Officer Vanderwork, testified that based on his observations, that he didn't see what he didn't recall seeing what color pants the subject was wearing prior to approaching, but that an individual, I guess last name Williams, Mr. Williams, appeared to be the person who best or most fit that description, and he appeared to be agitated. And per the dispatch, the subject was yelling and acting crazy. And so he believed Mr. Williams to be the person that most matched the description, and that Mr. Williams was wearing a long sleeve gray t-shirt, as well as a gray sweatpants. The video was replayed, and Officer Vanderwork was questioned about what color pants the defendant was wearing, and as the court indicated, because I think the court asked for the video to be played so that I can even see what he was wearing, and as his luck would have it, he's wearing gray sweatpants and a gray t-shirt with a gray hood, and is in the area at the time. He's wearing a crossbody bag, and he was questioned as to whether or not there was a firearm, to which he responded and said yes. The argument of the defense is that it's an unlawful search, and that I think I've already fleshed out, at least for this record, the court's ruling as it relates to the objection for hearsay as to what was provided by dispatch, and outside of that, the door was open for that information to come in under Vanderwork. And so we have an issue of whether or not the search of the bag was lawful, or if it violated the defendant's rights. The charge of carrying a concealed pistol at the time of trial would require the prosecution to put forth evidence beyond a reasonable doubt that the defendant knowingly carried a pistol. It does not matter why the defendant was carrying a pistol, but to be guilty of this crime, the defendant must have known. Are you taking pictures?
No.
Must have known that he was carrying a pistol. Second, that the pistol was concealed on or about the person of the defendant, and complete invisibility is not required. A pistol is concealed if it cannot be easily seen by those who come in ordinary contact with the defendant. The argument, again, of the defense is that the officers were required to Mirandize the subject before they could question him during a detention. And I find that argument to be faulty, for the reason being that if, and I believe the defense has answered that question, if an officer is doing an investigation, or they're making a stop, or they have the right to stop the subject, and they can ask questions about whether or not there's a weapon or a firearm being carried for officer safety. I think that's undisputed under the law. We had Officer Vanderwork testify that he set up shop to observe for 5 minutes prior to going in to wait for extra assistance before going in, because of the nature of the call. Therefore, it's clear that officers are approaching this from an officer safety standard. And then when the officers approach, and we have 2 individuals who are Black male, and 2 individuals who are wearing gray sweatpants, and 2 individuals who actually have one gray t-shirt. One obviously more agitated than the other, but not necessarily enough information to cause an officer not to, or to dispute their, or are you raising your hand for me, sir? Oh, okay. Not to cause an officer to stop their investigation just based on that. They're proceeding with the investigation and questions is posed allegedly to Mr. Walls, and he answers and says, yes, I have a firearm on me. It's no longer an unlawful search based on that, because it's telling them that he has a firearm on him, and for officer safety, they can do a pat down and secure weapons while they're doing an investigation. Based on that, the court is satisfied that there's sufficient probable cause as to count 1, weapons carrying concealed. That will be bound over to the circuit court for a bind over date of August 21st. That is a date that the circuit court gets the file from the district court. You do not need to appear in court on that date, okay, sir? Your next court date will be a pretrial unless your attorney makes a motion to have you rearranged for some reason at the circuit court level. And your next court date will be a pretrial. Mr. Young will be made aware of that. Do you have any questions for the court today? Will say the 2,000 personal recognizance, and that will continue. Any additional matters for the record?
Nothing from the people, Your Honor. Thank you.
Nothing from the defense, Your Honor. Thank you.
Thank you. You're all set. Slester. On the record in the matter of the people of the state of Michigan versus Trace Slester, file number 24-02126, counsel appearance.
Good afternoon, Your Honor. I'm May Cumber on behalf of the people.
Karen Robinson, Assistant Public Defender.
Okay. Slester? Okay, very good. Today's date set for a preliminary examination, and we're ready to proceed, correct?
That's correct, Your Honor.
Yes, Your Honor.
Any preliminary matters?
Nothing from the people.
We would just ask for the rule of sequestration, Judge.
Sequestration is ordered. How many witnesses?
2, Your Honor.
Okay, you can call your first witness.
Okay, we'll call Deputy Nabil Kanaze.
So let's be on this. Let's see. Impeachment.
I'll finally amend that. Call. Witness, Your Honor.
Who are you calling?
Thank you. We'll call Officer Nicholas McMiller.
What's going on over there? Is it a party?
wedding.
Oh, it's a wedding. Okay, do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Thank you. Can you state your first and last name and spell both?
Nicholas McKeevy, NICHOLAS, MCKEEBY.
You can proceed, counsel.
Thank you. Officer McKeevy, where are you employed
In the city of Lansing,
and in what capacity?
Lansing Police Department,
And how long have you been with the Lansing Police Department?
since May 9th, 2022.
And in what role do you serve in the Lansing Police Department?
Patrol.
Were you working on July 17th, 2024?
I was.
And on that date, did you have a reason to respond to the area of 141 Garden Street?
I did.
Is that the city of Lansing,
Yes, ma'am.
Ingham County, Michigan? What was the purpose of your response to that address on that day?
It was a call for priority backup from the county.
And what's priority backup mean?
It means that the officer was in trouble or in immediate situation that requires us to run to them to provide assistance.
And were you the first officer on scene, aside from the initial Eaton County deputy that was calling for assistance?
Yes, sir.
When you arrived on scene, what, if anything, did you observe?
Once I exited my vehicle, I approached the house. Upon approaching the house, I observed the Wiin County deputy have a subject handcuffed on the ground. As I approached him, he advised me that the subject had tossed a gun into the house.
Objection as to hearsay?
Objection.
That is nothing on the court, she was being official what the officer is doing next.
Oh, okay, the objection overruled.
So upon walking up the front steps of the residence, I observed an open front door to the residence. Upon approaching the open front door, in the entryway of the residence, I observed a black handgun be lying on the ground. I then recovered this firearm.
And you said that you had to walk up into a porch to be able to see the front door there, is that accurate?
Yes,
How far away was the deputy with the handcuffed suspect on the ground from the porch approximately?
a few feet.
Still in that same kind of yard curtilage area?
Yes,
And did you observe any other persons inside the home immediately near the firearm when you arrived?
not inside the residence.
And what type of firearm did you observe laying on the ground?
It was a handgun.
Do you recall the make, model, or any sort of description of that handgun?
It was a black handgun, Glock model with an extended magazine.
And you said you collected that handgun? What did you do after you collected that handgun?
I collected that handgun. I returned to my patrol vehicle, made the firearm safe, secured it in my patrol vehicle before returning to provide further assistance.
Cross-examination.
Yes, correctly, Your Honor. Deputy, correct?
Officer.
Officer, okay, sorry. Officer McKinney. So you stated that you didn't see anybody that was inside of the residence. Did you see anybody that was outside of the residence besides the subject?
Yes, ma'am. I saw a few people. I can't remember how many people there were, but there were people standing around the location where the deputy was,
So at least 2 other people?
to my recollection.
Okay. And they were, you said they were outside of the residence?
Yes, ma'am.
About how far away were they from the subject who was handcuffed?
I would say within 20 yards.
And can you remember, if anything, what they were doing?
I don't recall them.
Did anybody make any statements that you heard?
I don't recall.
Nothing further.
Redirect? I think you have to make you may be excused. There is a sequestration order, so you're not to discuss your testimony with any other witness. You can call the next witness.
Thank you. Now people call it Deputy Nabil Kanazi.
This is sequestration order. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
State your first and last name and then spell them both for us.
Nabil Kanazi, Nabil, Kanazi, Kanazeh.
You can proceed, counsel.
Thank you. Deputy Kanazi, where are you employed?
Eaton County Sheriff's Office.
And in what capacity are you employed with Eaton County?
I'm a deputy.
And what do you do as a deputy for Eaton County?
I work on the road to take calls, investigate crimes.
Were you working on July 17th of 2024?
Yes.
And on your shift that day, did you have a reason to respond to the 14 warehouse at 8757 Delta Drive?
Yes.
What was the purpose of your response to that address on the 17th?
It's shoplifting and retail fraud.
I'm sorry, can you repeat that?
Retail fraud, shoplifting.
And in taking that retail fraud or shoplifting report, were you able to determine what had been alleged to have been stolen?
Yes.
And what was that?
It was a 9mm magazine.
And were you able to observe anything that would have supported the allegation that something was stolen on that day?
Yes, I reviewed the surveillance video, observed a male take the magazine and place it down his
front part of his pants and places hooded sweatshirt over it.
Did a hooded sweatshirt, were you able to see a fairly good description of what that suspect was wearing?
Yes.
Can you describe the clothing at that time?
Yeah, it was a white hooded sweatshirt and some white print on the back.
And were you able to see the type of pants that individual was wearing?
It was a darker pair of pants. Also had white and black shoes on.
And observing that video or any other evidence in response.
Have you stop real quick? This is ridiculous. I'm sorry. Okay. Sorry for that. You can just say.
Thank you, Your Honor. And observing that surveillance video, were you able to see where that individual went after he placed the magazine into his pants?
Yes, he walked out of the store, past all points of sales, and got to a gray color Honda Odyssey.
And were you able to observe the license plate of that Honda Odyssey on the surveillance footage?
Yes.
And what did you do with the information that you observed regarding that license plate?
I ran the plate, came back to an address on Gardner Street.
Objection as to hearsay,
What portion are you rejected to the?
to the
plate
actual
being run?
address, that the information that was received from the search.
Okay, would you want to respond to the objection?
And again, that is not being offered for its truth, it's being offered to show that the officer did not see his investigation.
Okay, the objection's overruled.
You see that address, what did you do next?
I went to the address to attempt to identify the subject.
And to be clear, you responded on the 17th.
Yes,
Was the shoplifting reported to have occurred on the 17th?
no, it was 2 days prior.
And when you responded to the address that matched the license plate when you ran, did you come into contact with anyone at that time?
Yes,
Who did you come into contact with?
I spoke with the registered owner, Shelley Wood, explaining why I was there, showed her photos from the surveillance, see if she knew who that subject was.
When you were on scene, did you observe anybody else at that time?
Yes, there were several people at the residence. While speaking with her, the subject I was looking for happened to be walking up the road and came to that house.
And what made you believe this was the same subject 2 days later?
Because the description, wearing the exact same clothing as 2 days prior.
Meaning that black hoodie with the white lettering on the back?
Yes.
And the darker pants?
Yes.
White and black shoes? And when you observed this individual walking towards you, what happened next?
I approached him, told him I wanted to talk to him about the Sportsman Warehouse. He quickly admitted to stealing from there.
Did he tell you what he stole from the Sportsman Warehouse?
I don't recall.
He did not deny stealing something from the Sportsman Warehouse.
No.
What happened after he made that admission?
I just told him I wanted to get his information for the report. He was walking towards the front door of the house. With his body language, I could tell he was very nervous and trying to get around me to get to the door. He said he'll go inside to get his ID, and I told him not to. Quickly went off the front door, and I grabbed a hold of him to stop him. So affecting Ross.
And prior to, or up to this point, were you able to identify or even confirm an identity for this subject?
I confirmed that it's the same subject I saw in the video.
As far as a name or a date of birth or anything of that nature, did you know any of that at that time?
He gave me a false first name of Trevon.
At the time that he gave you that name, did you know it was false?
Yes.
And how did you know that?
I paused for a moment. With body language, like 25 years experience, I could tell he was lying.
You're talking about body language and being nervous. What different indicators did you have to believe that he was either lying or being nervous when he was answering your questions?
I'm sorry, one more time.
We were talking about body language and being nervous.
Yes.
What indicators did you observe that made you believe that the subject was lying or was nervous as you were interacting with him?
I paused for a minute to tell me his name. Usually you don't have to think about what your first name is. Kind of moving around a little bit, looking around.
And as this is going on, you said at some point he pushes past you.
He goes around me to the front door. And quickly runs over there.
At that point, had you told him he could go get his ID from inside the home?
I told him not to go inside.
And why did you tell him not to go inside?
I did not want him to get in the house because I didn't know it was in the house, and I wouldn't think he would come back out. And I haven't identified him yet.
What happened after he attempted to run to the door?
I grabbed a hold of him. He was still able to open the door. As I was holding him, he reached in the front part of his pants, pulled out a gun, and threw it inside the house.
And how did you know that what he grabbed was a gun?
I could see it.
Are you familiar with what guns look like?
I am.
And as this happened, as he's pulled the gun out from his pants and threw it into the door, the door was open?
Yes, he was able to open the door.
Did the door remain open?
It did.
And were you able to call for assistance at that time?
I did. I asked for priority backup.
As you're waiting for backup to arrive, what happened next?
We fought. I was able to get him on the ground and trying to handcuff him. He kept pulling away from me, asking for other people to help him that were there.
Did those individuals give him assistance?
No.
At some point, are you eventually able to handcuff him?
Eventually, yes. After a struggle, I was able to handcuff him.
As you're finally able, did you have to, at any point, did you believe that you might need to use additional force to detain this suspect?
Yes. Eventually, I pulled out my taser and I told him I would tase him if he didn't stop. And at that point, he finally gave me his other arm. I had one arm secured. And then when I got my taser out, he gave me his other arm.
Were you wearing a full police uniform at that time?
Yes.
And you identified yourself as a police officer at that time, or it was when you were telling him not to go into the home?
Yes.
And why you were there investigating the retail fraud?
Yes.
At that time, did other officers arrive?
Yes.
And were you able to convey to them about the firearm being thrown into the home?
Yes.
Prior to the individual pulling the firearm out from his inside of his pants, were you able to see it at all?
No.
Did you know that he had that on him when you first made contact?
No.
And eventually, were you able to identify who this individual was?
Yes.
And who were you able to identify him as?
Trace Slester.
And how did you come by that identity?
I spoke with the registered owner of the vehicle. He had given me the name, and other officers helped me identify him.
Would you recognize this person if you saw him again?
Yes,
Do you see him in the courtroom today?
I do.
Can you describe where he's sitting in an article of his clothing?
Yes, he's sitting at the table wearing a black hooded sweatshirt.
For the record, we have identification.
Any objections to ID?
No objection for purposes of hearing.
ID is noted.
Nothing further.
Cross-examination.
Yeah, sure. Deputy, you stated that you went to the Sportsman warehouse and viewed the surveillance video. Did you then immediately, on the same day, go to the 141 Garden address?
Yes.
Okay. And was it immediately afterwards?
Not immediately.
Okay. About how long would you say?
Probably a few hours.
Okay. And when you looked at the surveillance video, did you speak to anybody that was on scene?
I spoke with security that reviewed the video.
Okay. Did they tell you if they witnessed anything?
Yes.
Okay. Besides security, did you speak to anybody else?
No.
When you arrived on scene, about how many people did you notice that were present in the area?
On scene at Sportsman or on scene at Gardner Street?
At the Garden Street address, thank you.
5 or 6 people.
About 5 or 6 people. Do you know if anybody was inside the house at the time?
I did not know at the time, no.
Okay, so you saw 5 or 6 people, and does that include the subject that you saw?
He wasn't there at the time I arrived.
Okay, so and then you stated you saw him walking up, correct?
Yes.
Okay, and when he started walking up, did you tell him to immediately stop?
No, I approached him and I said I wanted to talk to him
Okay, and he stopped and talked to you, correct?
briefly.
Okay, but he answered your questions?
Yes.
At any point in time, did you read him his Miranda rights?
No.
You stated that he gave you a name of Trayvon. Did he say what his last name was when he gave you that name?
No.
Okay, so he just said Trayvon?
Yes.
Did you hear anybody else call him Trayvon that was at the scene?
No.
After he was placed under arrest, did you do a pat down?
Yes.
Okay, did you find anything else on his person?
Call. Nothing illegal that I found.
Nothing that he would have been arrested for?
Correct.
Do you know if anybody else was arrested on scene or had any firearms on scene?
Objection, Your Honor, relevance. It's irrelevant.
Your Honor, it could go to ownership of the firearms, and there were multiple people on scene. The firearm is alleged to have been thrown into the house in the doorway. Just
Ownership and element.
well, I think control is.
Well, you didn't ask about control, you asked about ownership, so the objections to stay. You can move on.
Were you wearing body worn camera at the time?
Yes.
Okay, and was it on and working?
Yes.
All right, and when you arrived to the 141 Garden address, you were the only officer that was on scene at the time until you called for backup, correct?
Correct.
Nothing further.
Very good, Your Honor. When you first approached the suspect, was he under arrest at that time?
No.
Did he speak with you voluntarily when you first initially approached him?
Yes.
Witness be excused.
Yes, Your Honor.
Yes, Your Honor.
Okay, thank you. I'm sorry, Deputy, is it Kanazi?
Yes.
Kanazi, there's a sequestration order, so you're not allowed to discuss any portions of your testimony with any other witness.
Yes, sir.
Thank you.
Thank you.
Okay. Any other witnesses?
Your Honor, keep arrest.
Is the defense calling witnesses today?
You're not.
You could proceed to argument.
Thank you, Your Honor. Based on the testimony today from Deputy Kanazi, who stated that he had responded to the Sportsman warehouse in response to a retail fraud, he was able to observe a surveillance footage of said retail fraud and able to observe an individual wearing a black hoodie with white lettering on the back of it, dark pants, put a gun magazine into his pants, walk out of the store and get into a vehicle. Deputy Kanazi was able to observe the license plate of that vehicle and do some investigation as to where that license plate was registered to. Responded to the home on that same day, Your Honor, and made contact with the registered owner of the vehicle. While he was speaking with her, he observed an individual matching the description of the individual that had stolen or taken the magazine from the Sportsman warehouse, wearing the exact same clothing, and appearing to be the same individual that Deputy Kanazi had observed on surveillance footage, approaching the home in which he was speaking with the registered owner at. That Deputy Kanazi approached that individual, and the individual voluntarily spoke with the deputy and admitted that he had in fact committed a retail fraud or stolen something from the Sportsman warehouse. I don't believe that we had testimony today as to what that exact item was, but that he did commit some sort of retail fraud at that time. Deputy Kanazi had asked the individual to identify himself, and at that point, the individual pauses before giving a name that the deputy believed to be false. The individual asked, or I guess stated, that he was going to go inside the home and get his ID, in which Deputy Kanazi told him he was not to do so. We heard testimony that Deputy Kanazi was in full police uniform and had identified himself as a police officer at that time as he was investigating retail fraud, and that when he told the defendant, or when he has identified as the defendant, not to go into the home and to stop, that the defendant attempted to run into the home, was able to open the door before the deputy was able to stop him from going inside, At this point, Your Honor, the defendant pulls a gun from the inside of his pants and tosses it into the open doorway. That the deputy was able to see this. He recognizes the handgun when it happened. Another struggle ensued and was going to take the defendant into custody. But during that struggle, he was able to get one handcuff on one arm, but continued to struggle to get a second handcuff on the second arm. He actually had to threaten the defendant with a taser before the defendant would comply with his commands to put his hands behind his back. They were on the ground struggling. But during this time, Your Honor, he was able to call for backup. And that's when Lansing Police Department officer Peavy arrived. When he arrived, he was able to see directly in the doorway where Deputy Canazzi had instructed him to go look for a firearm, a handgun there, a Glock style handgun or firearm at that point, Your Honor. He was able to, with an extended magazine, he was able to seize that firearm, make it safe and tag it into evidence at that time. Deputy Canazzi did testify that prior to the defendant pulling the firearm out from inside of his pants, he was not able to see the firearm on the defendant and did not know that he had a firearm on him when he initially made contact. Based on that information, everybody else, if I use over the charge of complaint.
Your Honor, just briefly, based on the information that we heard today, Your Honor, and I would just ask the court to look at all of the evidence in this case. We heard from two different officers in the case that there were multiple people that were present outside of the home. There was no information admitted as to what was going on with them or what was happening. We also heard that Mr. Slester was not read his Miranda rights. Therefore, I would ask that you not find the case over.
Mr. Slester, you were present when I explained what the purpose of a preliminary examination is, so I won't go into all of that. However, we did hear testimony today from first an officer from the Lansing Police Department, Nicholas McKeevy. He testified that on or about July 17, 2024, he reported to the address of 141 Garden, City of Lansing, Ingham County, State of Michigan, which makes venue in this court appropriate in response to a priority backup call from Eaton County. When he arrived, he testified that he approached the house that a deputy advised for him to, or he noticed, I should say, that the deputy had a suspect on the ground, and he approached the entryway of the entry to the doorway of the home at the direction of the deputy. And as he did so, he located a black handgun Glock style model with extended magazine. We then heard from Deputy Nabil Kanazi, who testified that he was investigating a retail fraud report or shoplifting from 2 days prior to the date of the alleged incident. He reviewed surveillance cam evidence and observed a male placed the magazine into his pants. He described the outfit to be a black hooded sweatshirt with pants gray colored, leaving in a gray colored Honda. He traced that back to the address of the registered owner. And when he reported to that address, he identified a subject walking in his direction who fit the description of what he saw in the surveillance, ironically wearing the same type clothing from 2 days prior. He stopped the subject to speak with them and questioned him about a larceny, to which he testified that the subject admitted to stealing something from the Courtroom warehouse. What that item was not made clear on the record. Indicated that the subject attempted to quickly move around him after being questioned about his name, indicating that he was going to the house to get his ID. Officer grabbed a hold of the subject. However, the subject was still able to open the door, and the subject the officer justified the subject pulled out a gun and threw it into the doorway. Officer called for priority backup. He testified that he and the subject fought. The subject kept pulling away and was asking others to come and help him, to which no one assisted or engaged. He identified the subject in the court as the person by the name of Trey Slester. And this complaint, we have 3 counts. We have a weapons carrying concealed, a police officer assault resisting obstructing, and a stolen property receiving concealed. The weapons carrying concealed will require people to prove first that the defendant knowingly carried a pistol. Does not matter why the defendant was carrying a pistol, but to be guilty of the crime, the defendant must have known that he was carrying a pistol. Second, that the pistol was concealed on or about the person of the defendant. Complete invisibility is not required, and a pistol is concealed if it cannot be easily seen by those who come in ordinary contact with the defendant. The testimony of Officer Kanazi was that when he first addressed this defendant, that he was not aware the defendant was carrying a firearm, that he questioned the defendant in stopping the defendant from retreating in the home, that the defendant took out a firearm, which the officer said he saw with his own eyes and threw it in the door. He testified that he's familiar with seeing a weapon or what a firearm looks like. And this is a very low standard, just more than mere suspicion. There's sufficient probable cause as to count 1, so that will bind over. Count 2, assaulting, resisting, or obstructing a police officer or persons performing duties. Officer testified that he was in plain or full uniform, that is, and he was performing his duties at the time. To prove it, the people will need to prove at trial that the defendant assaulted, battered, wounded, resisted, obstructed, opposed, or endangered. In this case, Officer Bill Kanazi, who was an officer for the Eaton County Sheriff's Department. Obstruct means to use or threaten to use physical interference of force or a known failure to comply with the lawful command. The defendant must have actually resisted by what he said or did, but physical violence is not necessary. Second, the defendant knew or had a reason to know that Officer Kanazi was a police officer and performing his duties at the time. Third, that Officer Kanazi gave the defendant lawful command and was making lawful arrests or was otherwise performing a lawful act. And so in this particular case, we had the officer testifying that he stopped the subject, that is, the defendant from retreating in the home, that when he grabbed him, the defendant threw a gun out, that at this time the officer is calling for priority backup and trying to take him into custody. He was pulling away. The officer used the term distinctly as they fought. I don't think anyone really questioned as to what that means, but he did testify about pulling away, asking others for help, and the officer having to reach for his taser to bring the defendant into custody. The court is satisfied that there's sufficient probable cause as to that count, and they will be bound over to the second court. Lastly, we have receiving and concealing stolen property. To prove it at trial, the people will need to prove that some property was stolen or explicitly represented to the defendant as being stolen, embezzled, or converted property. Second, that the defendant bought, received, possessed, concealed, or aided in the concealment of that property. Third, the defendant knew or had reason to know or to believe that the property was stolen when he bought, received, possessed, or concealed it, or aided in the concealment thereof. And so the testimony here that we have for the purpose of probable cause is that when the officer is investigating a stolen property or larceny, he reports to the address that the vehicle seen on the surveillance camera identifies or registers back to, and when he gets there, he sees an individual who matches the description, wearing the same exact outfit as seen on the surveillance camera. And when he questions that individual, individual who's identified in the court as the defendant admits to stealing something from that location of the Sportsman warehouse. So the court is satisfied that there's sufficient probable cause as to the count of receiving, concealing. All 3 counts will be bound over to the circuit court for a bind over date of August 21st. And that's the date that the circuit court gets the file to the district court. And so Sousa, you do not need to appear in court on that date, okay? court date will be a pre-trial and your attorney will be made aware of that. What's your address, sir?
1522 Aurelius Road.
Did your address change?
1576 Aurelius Road.
Did your address change?
You said when? When I had got out on bond.
1576 Aurelius?
Yeah, really.
Apartment 3.
I see 1522. And your phone number?
517-528-9935.
9935?
Yes.
Is that 9925?
25. Y'all got 9925. It's 9935.
No. Okay. Do you have any questions for the court at this time, sir?
No, you're.
Your bond will continue. Any additional matters for the record?
None from the people, thank you.
No, Your Honor, thank you.
Okay, on the record, in the matter of the people of the state of Michigan versus Jace Buckley, file number 24-01572 FY, and people of the state of Michigan versus Tavari McMiller, 24-01574. Council with minutes.
Good afternoon, Your Honor. Natalie Nathan on behalf of the people.
Good afternoon, Mayor. Please, this honorable court, Kareem Johnson, on behalf of Jace Buckley, who's seated behind me in the courtroom.
Good afternoon, Your Honor. Ron Berry, appearing on behalf of Tavari McMiller, who is seated behind me for purposes of.
Okay, so today was the continuation of exam that started previously, and we opened proofs for the purposes of body cam evidence that was presented. And so the prosecution wanted to call witnesses on that new evidence, and also witnesses in references to the defense's suppression arguments, correct?
That's correct, Your Honor.
Okay, any preliminary matters before we call our witnesses?
Thank you, Your Honor. Your Honor, just the court is aware the people do intend to admit body camera from the other officers that we will be calling today. The purpose of that, Your Honor, would be to comply with Michigan Rules of Professional Conduct, Rule 3.3A1 and candor towards the tribunal, to say that a lawyer shall not knowingly make a false statement of material fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. It's the people's position, Your Honor, that the evidence as it was admitted at the initial exam by defense misstates not only the information on that camera itself, but on the additional body cameras by the officers that were on the scene, and that the arguments made by defense were a misstatement of what actually was included in not only the evidence that they had at the time of the preliminary examination, but additionally the evidence that they received after the fact. And to correct the record, Your Honor, and make sure that the court has the full picture and that there is full candor towards the point of people being seeking to introduce evidence as we proceed with different witnesses.
And Your Honor, I stipulated to it for the purposes that it provides us an additional angle to help the court to make the decision as to whether it was an illegal search. So like I said, I stipulated to its admission, and as such, request in return the stipulation, if the people would agree, to my proposed exhibit G that I had attached to my brief for the frame-by-frame screenshots from said exhibit.
People do not stipulate to the admission of that exhibit. The reason being, there is no foundation for that exhibit. It's unclear how that exhibit came to be. It appears to be evidence that the defense created, unknown how he created it, whether or not the screen grabs are accurate screen grabs. And I believe that the expert witness can testify about screen grabs and why they may be problematic. But ultimately, Your Honor, there's no person that can lay a foundation as to that evidence, and therefore we did not stipulate to its admission.
That's fine. The court can use it as a demonstrative evidence instead. Thank you.
Any other matters?
I'm confused here. The prosecutor saying that we lied when we were last here, because the prosecutor was here before, had none of those problems. So I don't understand what the prosecutor just said or reading that court book. But surely, when I was here last time, I didn't lie or mislead the court.
No, I think she was saying the officer may have lied.
No, she quoted the rule of professional conduct.
Yeah.
That doesn't apply to officers.
Oh, I guess I misunderstood what she was saying then.
So if that's what she's accusing me of doing, I think we'd have a hearing on that right now and pull the record. Because I surely didn't lie to anybody or mislead the court in any way, shape, or fashion. We had a hearing. We took proofs. The prosecutor who was over at that table at that hearing was satisfied and closed the proofs. And the court allowed us to come back here for a very limited purpose. I'm ready to proceed on that limited purpose. I believe Mr. Berry's exhibit was admitted and allowed without objection last time we were here.
Actually, that reminds me, we did discuss it at the last hearing, and I thought that we had said on the record that both the sides were admitting those exhibits, but again, I don't want to be accused of lying again. But
do you have the exhibits?
Exhibits that I intend to admit, Your Honor?
I don't know what, I don't have any exhibits in my file, so I'm asking what exhibits you're referencing that was admitted.
I just want to say one thing, especially since it's now being clarified.
Well, what exhibits are you talking about though first?
To my brief, so when the people wrote their brief and provided this court an exhibit that hadn't been admitted yet, that I think she's now seeking to admit, unless she's talking about something else. I don't have great hearing, Your Honor, so I was having trouble hearing the court just now, and then I guess may not have heard everything Ms. McMiller said. I thought she was seeking to officially admit the exhibit, the video of Officer Vanderwork So that way it has the complete story and accuracy for the court and entire candor. I don't know if that's the exhibit she was admitting or not.
She was seeking to admit another officer's body cam.
To be clear, at the last hearing that we had when we adjourned to this date, defense did stipulate to the admission of People's Exhibit number 1. People never admitted or stipulated the admittance of Defense Exhibit G. In fact, that exhibit was not actually broached on the record. What Mr. Berry had said was that we could stipulate something else, and I said that's not what people are stipulating to. He was referring to whether or not we would need to call additional witnesses, or we could just use the briefs and the proposed evidence that was submitted by both parties. I was very clear that we were not stipulating to that, but that we would be seeking to have a hearing on the matter. In regards to why I'm quoting the rules of professional conduct, I absolutely believe that the way the questioning came out and the arguments made, with all due respect by Mr. Berry specifically, were that certain things were happening on video that were not happening, and the portions of video that were cut out that Mr. Berry did not play for this court that he had available to him would directly refute the arguments he was making to this court.
Yeah, well, listen, what I'm gonna say is one thing. And I'm gonna give Ms.
Well, let me
McCollum.
stop you, because I'm trying to get clarification on this first before I let you respond. So you're saying that the way he questioned the witness in the portion of the video that he played didn't show?
That exactly, Your Honor. What I'm saying is that the portions of the video that Mr. Berry played, and the arguments that he made regarding those, the portions of the videos that he played, and regarding the questions that he asked, is directly refuted by the video evidence that we have. And I can give the court an example that would not be in evidence as of yet. To just give an example of what I'm talking about. Actually, it is in evidence, Your Honor. In Defense Exhibit D is Trooper Delapel's body worn camera, and in Defense Exhibit B is Trooper Golden's body worn camera. There was extensive questioning of Trooper Golden as to whether or not he had called out the plate at the time of the traffic stop. Trooper Golden's initial response was, I think we did, I believe we did. That questioning continued in a very argumentative fashion to the point where Trooper Golden eventually said, maybe we didn't, I guess I'm not sure. And then Mr. Berry then argued that they absolutely did not call out the plate when they made the traffic stop. In both of those exhibits, the very first thing you hear, if you play them from the beginning, Your Honor, is Trooper Delapel calling out the plate in that traffic stop. Trooper Delapel and Trooper Golden are in the same vehicle. That's just one example of something that Mr. Berry argued did not happen, but the evidence that he admitted shows that it did happen. He just chose to show this court a small portion of that.
Okay, so what you're saying, this evidence is already admitted, but that he didn't show the portion that would dispute what his question was.
Something.
Okay, got it. You can respond, sir.
Yeah, this was never breached as a subject with me to go back and look at to kind of look and verify. I can stand before you right now and tell you, I don't know, I don't recall. I have to go back and look and see whatever was in there. One thing I will say, I'm gonna hold myself in my candor on this. I don't know that I've ever been accused in 18 years of lying by another attorney. You can say a lot of things about me and you'll probably be right, but a liar ain't one of them. And I'm just gonna leave it at that.
So it sounds like you just playing the record that you're not a liar, but that you're not necessarily objecting to her playing the entire exhibit that you admitted.
My position in this case has always been, let everything come in so the truth can be set my client.
Okay, sounds good. So air that out, and this doesn't seem to have anything to do with your lines of questioning. You can proceed to call your first witness. And what are we calling witnesses? So I'm clear. The body cam right now?
I'm sorry,
is your first witness going to be in reference to the newly admitted body cam?
The first witness, Your Honor, is, I would be seeking to admit his body cam that has not been admitted, but I would also be claiming People's Exhibit number 1 that has been admitted.
Okay, you can call your first witness.
Thank you, Your Honor. People call Robert later.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
You can state your first and last name and spell them both.
Robert Leiter, ROBERTLEITER.
Thank you. So where are you employed?
The City of Lansing.
And in what capacity?
I'm sergeant, assigned to a violent crime unit.
And what police department is that with?
The City of Lansing Police Department,
How long have you been with the City of Lansing Police Department?
almost 11 years.
Since you assigned as a sergeant to the Violent Crime Initiative, can you tell the court what the purpose of the Violent Crime Initiative team is?
Mainly to reduce violent crime in the city.
And how do you go about doing that? What are some ways you do that?
We talk to our detective bureau. We have informants to kind of guide us to specific people we need to be looking into. Our detectives, through their means of their investigation, come up with suspects, people of interest, and then we basically try to find those people. Sometimes the detectives want to talk to them, sometimes they don't, or if they have concrete evidence, like a video, they know this person did it, they'll tell us who did it. And we'll find those people.
And do you work in conjunction with any other special teams?
Yes, I work with the Michigan State Police,
And what team within the Michigan State Police do you work
the
with?
Safe Cities Partnership.
And can you explain to the court how that partnership between VCI and the Safe Cities Partnership kind of works together?
Yeah, so every day we have a daily brief at the Lansing Police Department. We have our information, they have information. They're usually in marked vehicles. So if we need a traffic stop made, we'll let them do it. Sometimes we do have our own marked vehicles that we will get into, but most of the time is we're like more like a surveillance team and they do our traffic stops.
And as a part of the Violent Crime Initiative or VCI, you assigned a body worn camera.
Yes,
Do you utilize that body worn camera while you're working?
I do long work, yes.
And does that body worn camera record your entire shift?
No, it isn't.
Why not?
Purely because the data from that would overwhelm the servers. A lot of it is useless. If we had it on all day long, you would see me singing and dancing in my car. It's just a lot of it's useless and doesn't pertain to evidence really.
Is there any type of protocol that you have as to when you are supposed to activate your body camera?
Citizen contacts.
You said what?
Citizen contacts?
And what about when you're conducting surveillance? Do you have your body worn camera on at that time?
No.
Why not?
A lot of sensitive information is broadcast. Certain individuals also, we have our VCI team, then we also have an undercover narcotics team, and some we don't want to have those voices recorded because that could compromise their safety. Just overall, I guess specialty information that we don't want to get leaked or something to exist to.
When you're working surveillance, do you utilize any sort of radio?
Yes, I do.
And do you utilize the same radio wave or station channel that regular patrol officers would use?
No, so we have the ability to use, it's called North Main, South Main, that everybody has access to. But we also have encrypted channels, which is mainly what we use for the Violent Crime Initiative. Our undercover narcotics team uses it the same way. Our SWAT team has an encrypted channel. Patrol has encrypted channels. Encryption isn't, it's not limited. Every force division has an encrypted channel.
And what is the purpose of an encrypted channel?
Protect information, sensitive information from being out, basically, because I don't know, like the Lansing's Most Wanted guy, he uses radio stations. A lot of the people who I have dealt with personally have a radio scanner. I've been on our SWAT team for 10 years. I know when I've been inside a house, I can hear our radio channel through their scanner app. So a lot of that is to mitigate that information.
And when you are using an encrypted channel, how does information, I guess, go out to your partner team, the Secured Cities policing team?
They operate under our encrypted channel.
Okay. So they're able to hear whatever's being broadcast at that time.
Yes.
And does any of the information that's broadcast on the encrypted channel go into any sort of computer, like a CAD system or a report system that's made available like that?
So the encrypted channel isn't monitored by our dispatch center. But if we have a major event or an event happening out, we will switch over to a more public channel, like where our normal road patrol officers are utilizing. And then they can probably start entering their CAD notes from that broadcast. But prior to it, no, nothing. There's no CAD call.
And is that information that's relayed over the encrypted channels, is that recorded and available to either our office or defense or anybody outside of who's listening to it in that moment?
No.
When relaying information on an encrypted channel, if you're the person relaying the information, do you direct it to one specific person or do you just broadcast what you're seeing?
We mostly work as a team. So if you see something, you get on the radio and everyone kind of recognizes that that person has something. and to let that one person talk. But generally speaking, if somebody sees something while they're on surveillance, it's open to anybody.
And after information is, I guess, relayed over that encrypted channel, is it part of the policies or protocols or procedures that somebody else will then confirm that they approve that information?
I would say it's more of a procedure than a policy. It's kind of like, hey, yep, I understood what you said.
And does everybody that has access to that channel, are they all required to confirm whether or not they approve that information?
No.
Is there any way to confirm who absolutely did hear that information versus who may have missed part of the information?
No.
When information is coming over the radio, is it always obvious as to who is the officer relaying that information?
I would say majority of the time we work in a small group, we know each other's voices, but there are some instances where the radio's faint or maybe they're whispering, because I've been on surveillance too where people are walking up right next to your car and you don't want them to know that you're in the car, so you whisper over the radio. So sometimes it can get challenging, but for the most part, we know each other's voices.
As part of the BCI team, do you discuss with your team different tactical ways to approach situations like traffic stops?
Yeah, we've definitely discussed, since I'm new in that assignment, I have a different philosophy and my tactical experience, I think, is a bit more than the other person. So we talk about that type of stuff. Sometimes in our daily briefs, or if we have a pre-planned operation, we'll go over it.
And what is the purpose of discussing those different tactical approaches?
It's just to put everybody in a safe spot. The person in the vehicle or the citizen that we're contacting, along with the officers, it's just safety for everybody.
When you are making you're requesting, I guess, a traffic stop to be conducted, if you're working surveillance, you're requesting the SCP team to do a traffic stop. Is it your policy that your entire team kind of responds to that traffic stop?
It's not a policy, but most of the time it does happen. Sometimes, I mean, I've been on surveillance too, like a big operation where we'll leave certain people at a location, and a couple people will leave off of that and go make the traffic stop with the troopers. Not everybody has to respond out there. Some people say come up with us, but I usually try and confirm, who's coming, or at least I'll direct someone to stay at the location.
And what is the, I'm sorry.
So at least yes, I'll do that.
And what is the purpose of having multiple units respond to that traffic stop if the Michigan State Police is already conducting the traffic stop?
Just more eyes on the car, more eyes in the neighborhood. I've been, everything based off my experience, I've been on traffic stops where people have ran from the cars, and my guys haven't been watching the vehicle with the state police, and I do. And I've seen 2 people run for cars. I mean, it happens. So we're just there as a contingency if somebody breaks out of the car and runs, that we can have a chase and
Would it be fair to say that the majority of the investigations that you and your team conduct, or the traffic stops that go along with those investigations, there is some sort of belief that this person may be either a violent offender or be involved with weapons?
A lot of my guys have background information on the people that we are contacting, and they know their history, so that is potential belief. But I'm also cautious on every contact that with somebody.
Why is that?
Even though I might not be like afraid of somebody, I'm still not gonna let my guard down. I'm not gonna be, turn my back to somebody. You just have a heightened sense of awareness, basically.
Would it be fair to say that you rely on your training and experience when you're responding to traffic stops as to
Objection leading.
You want to respond to the objection?
When you're responding to traffic stops, what do you utilize, if anything, that will help you determine what different tactics or procedures you will use in that traffic stop?
Yeah, so like I said, I've actually been a cop. I worked for 2 different agencies. Worked for the Lincoln County Sheriff. I've been in Lansing for 11 years. I have a lot of experience in making traffic stops. I can't even tell you how many stops I've made in my career. Every stop's different. It's just kind of my experience that I've built up over the years on how I'm going to respond to that specific traffic stop.
You said you can't even tell us how many different traffic stops you've made within your career. Is it safe to say, or can you say how many of those traffic stops involve a weapon within the vehicle?
I've never kept that statistic, but it'd probably be pretty high.
Have you ever been shot at by somebody who had a weapon in the vehicle?
The objection is relevant. Do you want to respond?
Yeah, sure. Thank you. It goes to the officer's way of why officer safety is important when responding to a traffic stop, even if in
I'll
that
withdraw the
moment.
objection. I thought that's pretty obvious, but I'll withdraw the objection.
Continue.
From a traffic stop, I've never been checked.
But you have found weapons in vehicles that you stopped.
Yes.
I want to bring your attention to the date of May 29th, 2024. Were you working that day?
Yes.
And what shift or were you working that day?
I believe that day was 2 p.m. to midnight.
And during your shift, did you have a reason to respond to the area of Lucy Street and Stillwell Street
Yes.
in the city of Lansing,
Yes.
Ingham County?
Yes.
And what was the purpose of your response to that location?
The state police got the traffic stop.
Prior to arriving in that area, was the BCI team engaged in surveillance on that date?
Yes, that we were. We were over at I think the address is 4245 West Valley Road, Kensington Trailer Park, for a balloon release for a homicide victim. So we were there at the park.
Why are you conducting surveillance of this balloon release?
Mostly for ensure safety of the balloon release, because we had been getting information that somebody else was going to come up there and cause harm to the balloon release. So I directed my team to actually park a patrol car at both the entrance. There's 2 entrances and exits to the park. There was a patrol car at each one of them, so everyone knew the police was there. Our overwhelming goal was to make sure there was safety out there for the people with the balloon release, and also potentially identify threats.
And the entire time that you were conducting surveillance, was information relayed over the channel regarding what the other surveillance officers were seeing?
Yes.
Were there multiple officers relaying that information?
Yes, there was. I believe 2, but it was more than one.
More than one. Now, when you arrived at that Lucy Street and Stillwell Street location, can you describe what you observed when you first arrived?
At Lucy and Stillwell, I saw the state police had a vehicle pulled over on the north side of the road. One of the patrol cars was in the driveway. The other one was offset a little bit, I think possibly in the grass. The troopers were already at the vehicle.
Were you wearing your body worn camera at that time?
Yes, I was.
And did your body worn camera record that scene as you were responding?
Yes.
I was testifying today, were you able to review people's proposed exhibit number 2?
Yes, I did.
And was that a fair and accurate depiction of your body worn camera on that date?
Yes.
I guess I would move to admit exhibit number 2.
Any objections to people to? Any objection?
No objection.
I'm just waiting to see if it's the same one that I have. Objection.
Okay, those 2 is admitted. It's just.
Forget lighter is this, let me scan the screen, your body worn camera.
Yes.
Can you say what the timestamp is located on the body worn camera?
It is timestamped at 17:59 and 9 seconds.
When you first activate your body camera, does the audio activate right away?
No, it said delayed by 30 seconds.
And why is that?
Because they don't want you to capture like a inadvertent comment or like private conversation, so it's a.
Let's play the body worn camera. I'll break from the fence and actually go fast forward.
What's it? What is this again? Your exhibit, it's already been admitted, so you can play the portion of that.
Is there supposed to be sound on this one?
There will be now, Your Honor, not initially, there was not. actually gonna pause this right here. Sergeant Leiter, we have get this pause at 1 minute and 32 seconds in. Can you tell who we are seeing on screen at this point?
That would be Trooper Golden.
And can you tell, in looking at this, there's a door, I guess, that we're looking at. What door is that to the vehicle?
That would be the driver's door.
Okay. Name that.
I got a woman move and I don't even know my name or nothing.
Describe what we just saw happen and pausing it at 1 minute and 38 seconds in.
Yes, so Trooper Golden shut the driver's door and then proceeded to handcuff the driver.
At some point during this video, are you contacted on your radio to go to an encrypted channel?
I believe I was already on an encrypted channel, but like I was saying earlier, our narcotics unit uses a different radio channel. We use a different radio because there just be so much communication. So I think the narcotics sergeant was getting a hold of me because he was assisting us. We had a couple of places where we were watching.
And at that point, what, if anything, did you do to your body camera?
I muted it.
Then again, for the reasons that you spoke of before about keeping the information that's supposed to be encrypted or not shared with the public off of a body worn camera?
Yeah, there's multiple reasons why I mute my camera. That was one of them. Our policy states I don't record conversations between other officers, and I wasn't contacting the public. I was just contacting other officers, so I was making phone calls.
Ahead. In 12 minutes and 58 seconds, we see in this pause frame that there's a steering wheel. Are you getting into a vehicle at this point?
Yes.
Play it from that point on. And then finally pausing it at 13 minutes and 9 seconds in. What did we just see you do at that point?
I made a phone call.
Do you recall who you called?
I believe it was Detective Ellen Larson.
Why did you call Detective Ellen Larson?
I was wondering if she would speak to the individuals that we had sent.
Can you tell the court what the timestamp is on your body camera at the time that you made that call to Detective Larson?
Yes, that is 18:12 and 19 seconds.
And 6:12 p.m. is that what that equals out to?
Yes, it is.
Prior to calling Detective Larson, do you have any reason to believe that you are going to be taking any of the passengers or occupants in that vehicle anywhere other than either to Lansing lockup or to release them on scene?
No.
After speaking with Detective Larson, did you learn where you should take the individual which you were arresting that day?
Yes, she said that she would talk about police operations center.
At the time that this traffic stop was made, that was not the plan.
No.
Going to People's Exhibit 1.
Everything was. Yep, right. What were they saying when they were pulling up in relation to this?
I was at 11 minutes and 20 seconds in. Again, this People's Exhibit 1 on scene here. I'm going to have you listen to what's being said, and I want you to report after hearing that if you can tell who is speaking in this side.
Both of them are going to jail for the gun? Two guns in the back, Deon and Jace. Jace Buckley. Both of them can go for those, I would say. 100%. I was just going to call Ellen. He can go for his warrant. He handed one of those back. What's his name? Tabari. That's his little brother. Tabari? Tabari. T-A-Y-V-A-R-I. I'll call.
Pause at 11 minutes and 49 seconds. Can you tell who was speaking during that portion of the body worn camera?
That's Officer Ben Brandford.
And do we see you in that body camera as well?
I don't see myself.
Now, in that portion of the body worn camera, we heard questions about the firearms that were in the vehicle. Did you hear what Officer Brandenburg said regarding the firearms in the vehicle?
I believe it's,
I can replay.
yeah.
So what was the guy with the guns? Both of them were going to jail for the gun? Two guns in the back, Deon and Jace. Jace Buckley. Both of them can go for those, I would say. 100%. I was just going to call him. He can go for his warrant. He handed one of those back. What's his name? Tabari.
Did you hear what Officer Brandenburg had relayed to you?
He said that there were two guns in the back, and then he watched someone hand one back.
What is the timestamp on the body worn camera at the time that Officer Brandenburg said that to you?
It's 1811, 611.
Now, were you present on scene when the occupants of the vehicle were taken into custody?
I was there, yes.
And what prompted them being taken into custody?
Essentially arrest them for carrying a concealed weapon.
When the occupants were being arrested, being the front seat driver and the two backseat passengers, the front seat driver was already under arrest, the two backseat passengers and the front seat passenger, when they were put into handcuffs, did you observe any of those three occupants appear to be surprised that they were being placed into handcuffs?
Objection, speculation.
Do you want to respond to the objection, speculation?
And I believe that this officer can testify as whether or not somebody appeared to be surprised. It is based on his own personal knowledge, it's based on common sense and everything he's in, is whether or not somebody would be surprised.
This
I can
officer
flush it out further if it would like.
This officer has no common sense or personal knowledge as to how my client acts when he's surprised. It'd be purely speculation. She asking this witness to testify as to how my client emotionally reacts to a situation he's never seen my client in before.
You said you can
I can flush it further.
push it further. To the, I'll allow you to do that.
Thank you. So that later, when you were observing the occupants on scene, is it fair to say that they were all fairly calm?
Yeah.
Was anybody up in arms?
No.
Did their demeanor change, there being the front seat passenger or the back seat passengers, either one, did their demeanors change once they were told to turn on the back?
I don't recall that. I don't.
Nothing stuck out to you as far as what's going on or what's happening, nothing like that?
I'd be speculating. So.
And ultimately, the decision was made by Detective Larson to have the occupants of the vehicle be taken to the ops center to be interviewed.
Yeah.
Nothing further. Yeah.
Question. Thank you, sir.
Okay.
You did call the detective that was investigating the underlying homicide, correct?
Yeah.
Nobody told you to call that person, correct?
No.
So if you, but it's your testimony that you didn't want to take these individuals to operation interview before the traffic stop, correct?
I had no intention of, from the down to the balloon release, it was not our intention to take anybody from the.
But you called the detective who was investigating the homicide case in the middle of this traffic stop, correct?
Yeah, secret related. She like to talk about.
Why call her?
To see if you
Why-
said to see if it related.
To see if she would have any, because I don't know the entire investigation from what the detectives have. There's probably, I think this was a lot of people, a lot of witnesses there. I wasn't sure if she knew who these people were. So I called her and asked her if she would like to speak.
And that detective works out of operations, correct?
Yes.
So you called the detective that works on operations in the middle of this traffic stop.
I want to say in the middle of it.
During this traffic stop.
Everything was handled and it was safe, so I made a phone call.
Now, when you first approached the car, you didn't see any weapons, correct?
I couldn't look in the car.
Okay. And you indicated you were wearing a body camera.
Yes.
We saw that body camera of yours around the front driver's side door of that car, correct?
Yes.
You were actually there. You were actually that close to the door.
I was near the door.
No further question.
You're in Kensington Meadows. At that time, anytime at Kensington Meadows, did you talk to Detective Larson?
Objection, Your Honor.
They literally admitted an exhibit and made a point of how he called Detective Larson and that he didn't know that they were going to be taking these people in beforehand. So I need to establish what communications, if any, he had with her before he called her.
Objections over.
Can you repeat your question?
Did you have any conversation with Detective Larson at any time while you're at Kensington Meadows that day?
I don't recall it at Kensington.
You don't recall, okay. Did you have any conversations with her at all that day prior to making the phone call we just saw?
Probably, yeah.
Okay, probably. We still, probably yes. Is that yes, or why do you say probably yes?
Because I'm not sure if I spoke with her that day. It was probably a long day. We just had a mass shooting. I don't know. It's the time frame.
Okay.
I had a conversation with her before that incident at some point.
That's right. And was it about the investigation for the homicide?
Yes.
Either that day or the day
nearby, yes.
Did you, prior to when you spoke to her and called her, did you give her names?
Of the people we had detained?
Yes.
Yes, probably.
Where did you get those names from?
Officer Brander.
When?
On scene, it was a Sunday.
Okay. You did not know those names at all prior to that?
No.
So the entire time you're conducting a surveillance investigation for potential safety and particular individuals that are there, you didn't know any of those individuals' names? I just got into the Viacom initiative in late March. Sure. So no, I was assigned to the patrol for that. Did, in your discussions with, well, actually, I don't even understand you to work that way. Did you did you or anyone else that you know of, at least, to have knowledge, right, foundation? Well, I'll just put this, are you aware as to whether or not Detective Larson knew that there was going to be police presence at the balloon release?
Objection, relevant.
Just want to respond to the objection.
I think it's fairly obvious, but it goes to credibility and to assessing whether or not there would be intentions to apprehend people and get, people leaving from the scene.
Your question was if he knew whether or not Detective Larson had knowledge?
Correct. Whether or not there's going to be police presence at the balloon release.
Okay, I guess it could go to credibility. I'll allow it.
Detective Larson shares an office with us. We have a big area of the police department. She is assigned to the Violent Crime Initiative, so she has an office and a cubicle in the same area where we hold our daily briefings. So I'm sure she knew that we were there.
Are you sure she knew for other reasons as well?
I don't know.
Okay. You're saying you're sure she knew. You gave this dialogue of how she shares office space and all that. And you're sure she knew, but she knew for other reasons as well, right?
I don't know what you mean.
Did you talk to Detective Larson specifically about the balloon release at all prior to that phone call?
Objection, asked and answered.
It hasn't been answered. It's been evaded.
Absolutely, it was been answered, Your Honor. He asked if you talked to her about that
No.
balloon release prior to.
What I asked before was whether he talked to Detective Larson at all, and then he said he couldn't remember that day or day before. And I don't know whether it was about the balloon release.
Your question now specifically as to whether or not he's to talk to her about the balloon release versus your previous question was whether he talked to her at all.
Yes.
His previous question was regarding the balloon release. You talked to her about surveillance of the balloon release prior to this phone call.
That's what I recall your question being, your previous question. Was asking him, did he talk to Detective Larson about the balloon release.
Perhaps somebody could tell me what the answer was, because I didn't ask it that way, so if they got answered that way, I took it as a different
I'll allow
answer.
him to answer it.
Did you just talk to Detective Larson at all prior to this phone call, specifically about a balloon release?
So we have a big area of our police department.
Yeah, you said that way before.
Yep, she shares an office with us. So I'm sure she knew that we were gonna be there.
You know what my question was? My question was, did you speak to her at all about the balloon release?
I did not pull her aside and talk to her about the.
Why are you answering it that way?
Objection, Your Honor.
This is argumentative.
Okay, you didn't pull her aside. Okay, but did you talk to her at all about a balloon release?
Objection, Your Honor, ask an answer.
It hasn't
No,
been.
he didn't. He said I didn't pull her aside. That's not answering the question.
I did not.
He needs to answer the question.
I did not talk to Detective Larson specifically. We have a briefing table where we talk about things. I did not have a direct conversation with Detective Larson.
Was she, okay, was she present during a briefing at a conference table where the topic came up about the balloon release? Okay, now we're getting somewhere. So she's aware of the balloon release. She knows you guys are gonna be there and that there's gonna be potential witnesses there, right?
I'm not sure this potential.
Okay, and so you would agree that we saw in this body camera here at 1810 is where Officer Vanderwork's talking about the names of the people and the individuals involved, right?
Yes.
And it was 1812 is when you're making that phone call to Detective Larson,
Yes.
right? And your intentions to call her was what specific purpose?
To see if these people that we entertained that you wanted to talk.
You did that over a cell phone, right?
My work phone, yes.
Yeah. Why was that never discussed with her? Well, let me back up and say this. Was it ever discussed in her presence at the briefing about the balloon release as to potential names or targets of interest, whether it be witnesses or suspects or anything of that nature?
Objection, Your Honor, relevance to this specific traffic stop.
As to whether or not these are the people that could potentially be interested in.
And I believe you could ask a question to if any of the occupants in this specific vehicle were discussed as potential witnesses or suspects that needed to be questioned ahead of time.
Well, let's.
But I guess this follow-up question can probably go there, but I think it's a little broad now. Was there any discussion about potential witnesses? Not asking him to name those
Yes,
witnesses.
thank you. I understand Ms. Maycomber's position. She's afraid that there's going to be, or trying to elicit names of other people for their ongoing investigation. I can respect that.
Without giving
That's my
names, he can
question.
answer
My
the
question
question.
is, were there people that were discussed? Not asking the names.
I'm sure there were specific people that we were.
Do you recall it, or you just, yes, because you say you're sure? Do you recall that, or?
I don't recall the specific names, but just how our general briefings go, we do talk about specific interests, but for this particular interest, I do not remember specific. Because historically, we talk about specific people.
Okay. But again, you don't remember, but you're not.
Correct.
Okay. Who else was present during that briefing?
All the troopers.
What troopers? On scene, you mean?
Yes.
Okay. So we
trying
got Golden, Delapel, Schaefer, Sergeant Williams, Harshman. Okay, and then
Is this briefing the entire secured cities unit? Is that what's going on?
The trooper aspect of it, we have secured city partnership in our detective bureau as well. I don't want to get those mixed up.
Okay.
They're completely separate. But as far as the safe city partnership goes, that it's assigned to the violent crime initiative, yes.
And so every trooper that we know that was on scene was present during this briefing where it was discussed the names without mentioning who they were of people, potential people of interest that may be at this building.
Yeah.
You know for certain whether or not any of the occupants' names of this occupants of this vehicle were mentioned during that briefing.
Reference to relevant, Your Honor, as to again, this traffic stop. He's talking about names relevant to witnesses or suspects in this homicide, not people that we want to speak to. Again, we're getting too close into an investigation as to witnesses or suspects.
The question was whether or not he knew if any of name of these
Absolutely.
individuals
Absolutely.
were mentioned.
Yes, Your Honor.
How's that getting into other suspects?
My understanding of the question was if any of the individuals in the vehicle were mentioned as names of witnesses or suspects in the homicide.
Correct.
So that's exactly what I'm objecting to.
And that's exactly it. If the people don't want to release that information because of an ongoing investigation, dismiss this case. because they can't hide that information if to show an improper motive to pull the car over. They can't dance and hide that.
Right, well, I think that by his testimony, that he called Detective Larson to give the names of these people to see if she want to talk to him. It's obvious, without it being stated, that there's a reason why he would pick up the phone and call Detective Larson and say if she wants to talk to these people.
Let's see
I
if
believe
we
Your
can
Honor-
answer it that way then, Your Honor.
I believe he already testified to that, is that they were leaving the balloon release and he didn't know if Detective Larson knew who these people were, or he wanted to speak with these individuals. It wasn't.
Well,
What
then
I
he
think is
needs to-
happening-
I think they want to know why, though.
What I
Why,
think-
just because it's not yet, because they were at the balloon release.
What I think they're happening is those names were mentioned.
Your Honor, what Mr. Barry thinks is.
Well, I'm responding
testimony
to
at
the
this
objection.
point.
Please stop.
Whoa. We don't go back and forth. We operate a professional in manners.
I agree.
And so I know how to tell someone to stop and let you speak. Okay, there was an objection, you wanted to respond.
Thank you, Your Honor. Essentially, they're dancing around the issue, not wanting to say whether or not to confirm our suspicions that these names were in fact released during that meeting. And instead, want to make it appear as if they were only calling because they were leaving the balloon release, as if there's nothing or no other reason that they had to believe anything as to these specific people. I want to confirm what I believe the court believes based upon testimony thus far.
I don't know if this is what I
Or
believe.
perhaps-
I'm trying
or
to get
least
at what
my
I
belief.
believe your question is.
Yeah, my question is the court basically surmised it, that there's knowledge of these people and I want to verify.
Your Honor, with respect, it's irrelevant as to the traffic stop. There's an officer's subjective intent during a traffic stop is not relevant in this case. It's whether or not they had an objective reason to perform this traffic stop.
Well, at this point, it goes to credibility because we have previous testimony as to what the purpose of the stop was and what the purpose of the surveillance was.
And I believe the court's direction as to what the additional testimony should be regarding.
And I put on the record, the case where that quote comes from, an officer's subjective intention do not matter, was a case in which the prosecutor admitted the sheriff was racially profiling the black driver.
Which has nothing to do with this case.
We have a testimony.
No, the Supreme Court said.
We all can't talk at the same time because as you all are aware, we have to create a record. So one at a time.
Here's the other thing on this. It's ironic that we start this hearing with Ms. Maycomber talking about misrepresentations and misleading the court with the questions. They're trying to mislead the court into believing, I believe, and I don't know confirm yet until I can get an answer out of this witness, that they knew they wanted to get people to go in to interview. They didn't know these specific people yet because they hadn't confirmed it with Detective Larson. So that's why he's calling and saying, hey, we got something, want to bring them in. Of course, that wasn't yet part of the plan because they hadn't yet been in custody.
Yeah, because we're seeing that wasn't part of the plan and the entire purpose of this questioning is irrelevant.
Yeah, I thought your questioning was to show that that was part of the plan.
Absolutely. That's what I'm trying to verify, yet or not. I believe it was. I'm trying to get him to either confirm or deny it. And the way he answered that question before, he was calling her to see if she wanted them to come in, doesn't say whether or not they had discussed that previously.
The objection is overruled. You can answer the question.
All right.
I think you know where I'm going with.
Not to delay us anymore, but could you please repeat the
Yeah.
question for me?
Were any of those occupants discussed during that briefing?
I'm gonna play ignorance list. I'm very new to this assignment. I don't know the Lansing hybrid gangs. I wasn't aware of anybody. I was a simple patrol officer for 10 years and 9 years before I got promoted. I'm not personally familiar with who I am now, but at that point, I'm hardly anybody. So I was not discussing names because I don't know. I was new. We'll be having discussions about which groups were involved in the homicide. 100% we were, because we know where our victim lied, and we were talking about people that might know him and might know who the accusers we think they are. So
Fair to say that factored into your decision to call her because you weren't sure whether these were some of the people that they wanted or not?
I have no idea who they were, so I called them.
But they could have been, and that's why you're calling.
Yeah, because I didn't know.
I have no further questions.
Redirect. Okay. Very question. Okay, and then Sergeant may be excused.
Yes, Your Honor.
Thank you, Sergeant Leiter. For the next witness.
You gotta do hold Kyle Jenks.
And what limited purposes are we? I mean, where are we, how far are we going?
How far are we going? What do you mean?
Like the topics of the limitations, I don't know. And my understanding and just the brief kind of understanding with it, with Mr. Maycomer, she wants to bring in a bunch of officers to try to help assist in credibility of the other officers. I don't know. I mean, I don't know where we're getting to with every single officer. If it's limited to what we just discussed, that's fine. I don't know to what extent we're going beyond that.
But they were called. Oh, that's not me, that's you. I was gonna say, I thought I was pressing something. They were calling witnesses in reference to the new evidence and suppression, is what my understanding was.
Yes, sir.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, ma'am.
You can have a seat. I just want to be in about 8 minutes, this computer is going to boot you out. So I'm thinking we should just do it now. And we start Zoom. Let me see here. It's the Zoom that times out.